encrypted, so they.
So we are in the middle of the Courtney Clenny status hearing. This is the only stream I can find, and it wasn't here when I first saw this article come up.
Downloading the records throughout, after actually downloading and reviewing the records, when I stumbled that they were encrypted, I continued just reviewing the records in its entirety just to make sure that they downloaded properly.
And after that, did you have any other involvement in this?
I relayed a photograph, or my finding of a photograph, to ASA Clenny.
StreamYard is really stupid with this.
Your involvement as a detective before becoming sergeant, even as a sergeant, have you come into situations where you've been notified by defense attorneys that they represent a client?
Now, there are no controls,
Yes.
so I can't pause. This is the filter guy. He said this is the first time he's had to filter something. What that means is he's supposed to look out for things that shouldn't be seen by the state, by the prosecutors. So the issue here is the state attorney, Khalil Quinnan, was able to see what could be privileged communications. And that's what this part of the hearing is focusing on, and they're talking to the guy that was supposed to filter the messages first.
I'm showing you what's been marked as State's Exhibit 1G for identification purposes. Do you recognize this?
Yes.
How do you recognize it?
Well, the email thread and then the letter, here's written like a letter of representation for
And-
Michael Haas, or Haas, however you pronounce it.
And have you had an opportunity to review this email thread prior to today?
Prior to today? No, I don't believe prior to today.
And today, did you have an opportunity to review that email thread?
Yes.
All right. And based off of that, is that a fair and accurate depiction of what you reviewed earlier today?
Yes.
Now the state would move 1G into evidence?
Judge, we object, same grounds foundation, I'd ask the voir dire to witness on the admissibility of this piece of evidence. This is not. Detective, Mr. Abdelhoff just showed you what has been marked, thank you, for identification of states 1G, and you testified you saw this today, is that correct?
Yes, that's correct.
Okay, you did not see this prior to your review of any of the text messages?
No.
Okay, today was the first day you saw this, correct?
Correct.
Okay, so this did not inform your decision or any efforts you took on behalf of this investigation, correct?
No, I believe that email came after the fact.
Okay, and you're not party to this email, correct?
No.
And you're not addressed on this letter, correct?
Mm.
Okay, and you don't know where it came from, right?
As far as, like, who printed it or where?
I have it, yeah.
I mean, there's a from.
Okay.
To the email.
But you don't know specifically what this regarding when it was sent or the context it was sent in, correct?
I mean, it's self-explanatory.
You think this is self-explanatory? Have you reviewed it?
Yes, I just read it.
Okay, so how did this affect your investigation and your testimony here today?
But has it?
Judge, I don't know what the relevance, I'm objecting to relevance, I'm objecting to foundation.
I don't know what it is. Some of it does sound like it's not relevant here. Do you guys want to proper?
Yes, Judge. So Mr. Haas, at some point in time, Mr. Haas was served a subpoena, actually on the day that the search warrant was executed, and the State Attorney Office was notified that Mr. Haas was being represented by Mr. Facidomo, who was reaching out to inform the state that he in fact represented a witness in the case.
Then what relevance does that have to this?
It's common practice, Judge, what I'm about to ask him in regards to when you're filtering things out, do you normally receive these types of documents, and then do you not take into effect emails and representations of this?
Okay. Sustained as to not entering this, but you can certainly ask him. You can ask him those questions regardless. Without what he does and he responds.
So specifically as to representation and attorney-client you know, if you're informed, or have you had cases where defense attorneys have come to you and said, hey, I'm representing this individual in a legal capacity?
Yes.
And in regards to that, are they then treated, their conversations that they are to have are treated differently than otherwise?
Yes.
Can you explain to the court how that process would be after you're informed specifically of that?
Well, I would, if it's something that I'm either physically around, I would remove myself from that conversation, or if it's an interview that I'm conducting and the attorney wants to be present, then I would remove myself from that.
At any point in time were you made aware of either Kim or Deborah Clenny being represented in any capacity by Mr. Prieto or Ms. Puglisi?
You said by which attorney?
By Mr. Prieto or Ms. Puglisi?
Yes, I ultimately became aware.
And in what capacity was that?
As being the attorneys that represent the defendant, Courtney Clenny, and then ultimately her parents.
And at what point in time did you become aware of that?
Of which one? The representation?
The representation of the parents.
That was after my involvement had concluded.
And when did your involvement conclude?
I believe it was in December.
One moment, Your Honor.
So yeah, it's hard since I can't rewind it. I don't want to talk between things. But if you missed it, some of you were in the premiere this morning. Jude Facadomo, the attorney
In your
representing the
communications-
parents.
I'm sorry, let me move to the mic. In your communications with ASA Quinnan, at any point in time did he make you aware that he thought there was a representation between Mr. Prieto, Ms. Puglisi, and the parents?
They're alleging misconduct
Yeah,
by Quinnen.
He expressed to me that he became aware that there was some sort of representation.
And is that at some point during this year?
Yes, it was this year, 2024.
So 2024, not 2023. Now I've got, who is this? Who's this speaking?
Good afternoon, Sergeant. Earlier, you testified that you showed up at the state attorney's office for work on another case, and that someone showed you some iCloud data, somebody in the state, correct?
Correct.
Who from the state showed you the iCloud data?
ASA Quinn, a computer that.
So it was Quinnen.
And based on your conversations with ASA Quinnen, you looked at the iCloud data, correct?
Just a matter of seconds.
A cursory look, and you could tell that it was not in a usable format, correct?
Correct.
And based on that information, you told them you need to get a new warrant because these have expired so that we can put this in a better format, correct?
Correct, that would be the only way.
And so you told that to ASA Quinnen, correct?
Yes.
And as far as you know, based on your representations, the state attorney's office and Mr. Quinnen did that. They sought secondary warrants, correct?
Yes, secondary one.
And then those secondary warrants were provided to you to put into a usable format, correct?
Correct.
And the iCloud information that you retrieved, or that was given to you at that point, contained the iCloud account for Courtney Clenny, correct?
Correct.
The iCloud account for Deborah Clenny, correct?
Correct.
And the iCloud account for Kim Clenny, correct?
Correct.
All three accounts.
Yes.
And at that point in time, you were established as the, I believe in the email it is referred to as the taint team.
Yes.
What does taint team mean to you?
In the context of that email is a filter.
A filter for what? What are you supposed to filter out?
Attorney-client privilege info.
Was communicated in the email.
Okay, since we're talking about the email, may I approach, Your Honor? I'm going to show the witness what I'm marking as Defense Exhibit A3 for identification. And this actually happens to be an email with you. Correct?
Yes, it is.
And that's an email between you and who?
It's from Clenney to me,
So
And
from
if you
Quinnen
could
to him,
reference the date on that email.
November 16, 2023.
2023.
So on November 16, 2023, Assistant State Attorney Quinnen emails you, correct?
Correct.
To tell you what specifically?
To what to filter.
And what does he tell you to filter in that email?
To filter any communications from a Manuel Recio, provides a phone number and an email address, 2 email addresses, a Frank Prieto phone number and an email address, and a Pam Corval phone number and an email address.
And Sergeant, you're familiar with the email that I've just showed you, correct?
Yes.
And you've seen that before today, correct?
Yes.
And here again today?
Correct.
And is it an accurate email between you and ASA Khalil?
Obviously, with the exception of the first part, in which the counsel's included because I sent it to him, but everything below that, yes.
I now move that, what did I say, Defense Exhibit A3 into evidence at this time.
No objection?
A3 will become Defense Exhibit C. Can I have it real quick so I can take it?
Yes. Thank you, sir.
filter is sort of redacted, except with redactions, the attorneys can usually see and stipulate what's supposed to be redacted. The filter is supposed to prevent the state attorneys from seeing it at all.
What parties to exclude? Does he also tell you what account to look at?
Yes.
And what account does he tell you to look at in that email?
It's the iCloud pertaining to public cloud.
So, correct me if I'm wrong, he, in that email very specifically with underline, tells you only to exclude Mr. Prieto and the other parties you mentioned from the Courtney Clenny iCloud, correct? So based on that representation, you are free to look at Kim Clenny's account without any filter, correct?
There were no instructions to filter those accounts.
So there was no filter for the Kim Clenny account, correct?
That's correct.
And there was no filter for the Deborah Clenny account, correct?
That's correct.
And it was your testimony earlier today, you couldn't get into the Courtney Clenny account, correct?
That's correct.
So in essence, there was no filter at all.
Correct.
Okay. You heard Detective Perez testify. You were here in court when Detective Perez testified, correct?
Yeah.
And he testified about filter protocols and what specifically that is, correct? What to him a filter protocols. And he said that includes an assistant state attorney, a separate assistant state attorney who would be assigned as well as a separate investigator, correct?
Objection, Judge, that was not his testimony.
Okay. Sustained rephrase.
Was there a separate assistant state attorney assigned to you for you to communicate with regarding filters?
As far as I'm concerned, it never got to that point
And why is that?
because I didn't filter anything.
If there was something that needed to be filtered, who in that email were you directed to respond to?
Nobody.
You might want to look on the bottom of that email. You're instructed to do what? Why don't you read the paragraph and then answer my question?
Okay. Can you ask your question again?
Yes. So had you found something that needed to be filtered out, who were you directed in that email to notify about that?
We'll ultimately provide the filtered content to ASA Clenney.
ASA. So your entirety of communications in this case were with Assistant State Attorney Courtney, correct?
All about Quinnen, because that's who there's a grievance against.
At the State Attorney's office?
Yes, by March.
Yes, by and large. Was there anybody else that you communicated with at the State Attorney's office?
I saw Assistant State Attorney Abelhoff. I've seen Assistant Attorney Kathleen Hope.
In reference to the filter and the protocols?
No, just generally.
Generally.
About this case.
Okay, I'll rephrase. In reference to the filter and what it was you were brought to do, did you have any other communications with any other state attorney other than ASA Quinn?
No.
I have nothing further.
So her whole line of questioning was,
Document?
it's all on Khalil Quinnen's plate. That ADA that we've seen in some of the motion hearings before, I'm not sure if they've shown him yet here, but they filed a motion against him, Jude Facadomo, and the Florida Association of Criminal Lawyers filed a press release with grievances about him. So,
Investigation was pretty limited, right?
Correct.
Okay. Now, you said that you were brought in to be considered an independent filter, is the word that you used, right?
I don't know that I use the word independent.
Okay, where'd you get the word independent from?
I believe counsel said.
Okay, but you do work with the Miami-Dade Police Department, correct?
Correct.
You currently have how many cases with the state's attorney's office?
Me as an individual
Yeah.
or
No, as a witness on any of their cases.
several?
Okay, so you'd agree with me that the Miami-Dade Police Department is somewhat of an arm of the state of Florida, the state's attorney's office?
Well, we're,
just say yes.
I mean, we can't, cases can't be prosecuted without the state attorney's office, and cases can't be prosecuted without the police department, so
You guys come part and parcel with each other, right?
it's, yes, we make the cases, and the state attorney prosecutes.
Okay, now you also mentioned that you found a photograph and you sent that to ASA Quinnen, right?
Yes.
Was that found on Courtney Clenny's phone or one of the other Clenny's phones?
I believe it's Courtney.
So on Courtney Clenny's phone, you discovered a photograph that displayed what you believe to be contain a password.
Correct, if possible.
How did you send it to ASA Quinnen?
I believe I emailed it.
So he should have a copy of just that photograph in his email.
Yes, it was ultimately, yes, I believe I emailed it.
Okay. Now, in this case, you had an opportunity to review the warrants, right?
Which one?
The search warrants for the Clenny parents' phones.
Briefly, I glanced at them.
Okay, and isn't it true that there is a seal at the back of that warrant indicating that you don't want this to be, that the public can't get access to it?
I don't remember seeing the non-disclosure affidavit, if that's what you're referring to.
Okay, but generally when you guys apply for search warrants, right, there's normally a request that the court keep that on the seal, right?
It can be.
Okay, and I ask this because you'd agree with me then that Mr. Prieto and Ms. Puglisi were completely unaware that the state of Florida was investigating their clients.
Yes, I don't know that they were aware.
Okay, were you aware that Kim Clenny was listed as a defense witness for Ms. Courtney Clenny?
No, I don't believe it was.
Were you aware that he was listed in care of Frank Prieto and his law firm?
When you say in care of, what do you mean?
Like when you are listed, for example, or some witnesses for the state are listed in care of the state, right? Essentially, if you want to communicate with them, you come to me,
Okay.
okay? So you're not aware that Kim Clenny was listed as it would be in the court file in care of the Prieto law firm.
No, I don't know that independently. No.
Okay, but you'd agree with me that once that's filed, that puts the state on notice, right?
I mean, procedurally, I don't know what that.
So
does
Quinnen
as
should have known.
far as how it affects the state.
Okay. Now, are you aware of any evidence, emails whatsoever, that would put Ms. Puglisi and Mr. Prieto on notice that the Clenny parents were subject of any investigation?
I'm sorry, ask it again?
Okay, are you aware of any evidence that would put the attorneys on notice that the Clenny parents were being investigated?
Not that I'm aware of.
Because you would agree with me, for example, with Miss Clenny, Courtney Clenny, when she's arrested, she's put on notice that the state of Florida is going to be prosecuting her, right?
Well, I mean, yes, she's.
Prosecuting's different than
Right.
investigating.
People come and talk to her, you know, or police officers or law enforcement come and talk to her about something. It lets them know that she's on notice, right? And she may have to get an attorney.
I'm sorry, let's who know? And, let's who
The
know what?
individual,
Let's the defendant know?
the defendant know.
I'm sorry, you're gonna have to clarify that.
Okay,
There's
all right.
a slew of
That,
questions.
yeah, so when, for example, like when someone is arrested, or, as I asked previously, if police officers come to speak to someone, right? In that moment, if they wanted to, they can say, you know what, let me talk to an attorney first, right?
There's, I mean, many factors to that, but yes.
Okay, but that moment of the police coming to talk to them kind of puts them on notice that something's going on, that they may want to consult legal counsel, right?
I suppose.
Okay, are you aware of any rule in law that says that defense attorneys are obligated to inform the state of Florida that they're representing someone when there's no case pending?
How would they be representing somebody if there's no case?
You're not aware of witnesses who have no cases pending appearing for deposition with their lawyers?
I'm sorry, you were saying in the context of somebody being, like, arrested.
Which now, you are aware that people can have lawyers without facing any criminal charges, right?
Yes, people can retain attorneys.
Although Selly family attorney is actually present in court today, right?
I was made aware of that, yes.
And they're not pending any criminal charges, right?
Not that I'm aware of.
But they have lawyers.
Yes.
Okay. Now, this email chain was brought into evidence by Mr. Avalon, which is an email chain between the attorneys and with the state's Mr. Clenney, right? That you said you reviewed.
Correct.
Okay. You'd agree with me that there's a back and forth concerning what constitutes attorney-client privilege, right?
I mean, there's several emails back and forth, yes.
But there's a disagreement as to what constitutes attorney-client privilege between the lawyers, right?
Which email are you referring to specifically?
So we can refer to the specific instruction about the investigator. So that would be on page, I'm going to turn your attention to page 3 of the emails.
May I see it?
Sure, may I approach, Your Honor? And for the record, I'm showing,
And while they approach,
the email is dated September 13th, 2022.
September 13th, 2022, so we're back in September 2022. It's probably going to be a retainer type discussion. But this status hearing was on the Courtney Clenny murder trial docket and not on the docket where they're co-defendants together on the laptop
For the
case.
record, I'm showing exhibit.
But this has to do with attorney-client privilege for Clenny's defense in the murder trial.
Now,
So it's all
that
overlapping.
Email at the top is on September 13th of 2022, correct?
Yes.
And that is to Khalil Quinnan, correct? Right?
Amongst other people, yes.
Right, but from Sabrina Puglisi, right?
Yes.
And she says, you didn't mention work product, which also deals with communications being privileged.
Okay.
You know anything about work product?
Uh-oh.
What I've heard,
Sabrina might have them.
Okay, but you'd agree with me that that's Ms. Puglisi putting the state aware on notice of a doctrine called work product.
Yes, and to then subsequently exclude.
September 2022.
And the two email addresses.
Okay. Now, when you were given filter instructions for the iClouds that you were tasked with reviewing, you were specifically told not to employ a filter on the accounts for Kim and Deborah Clenny, right?
Correct.
And also to be clear,
Well, but may I clarify? It was not so much specifically to not employ a filter, it was to solely employ a filter on the account of
There-
Courtney Clenny.
there was no instruction that this does not apply to the other two accounts?
Yes, it's just the way that you're phrasing it.
Correct, so he specifically told you the filter instructions I've given you do not apply to the Clenny parents' accounts.
Yes, it's only relevant to the one.
And you received no instructions as to the Clenny parents' accounts of what you should be looking out for.
Correct.
Okay. Now, you're familiar with Cellbrite, right?
I am.
Okay. And when a Cellbrite produces something on a phone, right? It gives it sometimes in an Excel spreadsheet, right? The messages.
That's very broad.
Okay, so when someone's reviewing text message, let's say from an iPhone that has been through Cellbrite, right?
Okay.
It normally will show the body of the text message on one side, right?
Yes.
And on the other side are the participants to the conversation, right?
If it's in an Excel format, yes.
So they're saying
Okay.
the names
If
were
it's in an Excel
visible.
format, right?
Correct.
And someone who's familiar with using Cellbrite would know if they needed to check the participants before checking the body, they just have to scroll to the left, right?
Correct.
Nothing prevents the person who is reviewing the Cellbrite information from checking who the participants are first before reading the body of any text messages, right?
No, I suppose not.
Okay. Any communication that would have been had between Courtney Clenny and her parents, where she's a party to those conversations, would be preserved on her iCloud, right?
No,
Why not?
because they were encrypted.
You don't know who encrypted them though, right?
Somebody did.
You don't know how they became encrypted, right?
Well, actually, let me rephrase. After, I believe it was there was a change in protocol from Apple.
Oh, so Apple could have done it,
Correct.
the encryption.
Correct.
No active, no act from either any of the Clennys.
Correct.
Okay. And so so were you guys seeking, if you know, the Clenny iClouds to see conversations that Miss Clenny Courtney wasn't a part of?
I'm sorry. What?
So this is what I'm asking, because you have the iCloud, right?
Okay.
Of Miss Clenny, right?
Correct.
Any conversation included with her parents would be on her iCloud.
If they existed, yes.
You don't need to go and get her parents' iCloud because you already have it on Miss Clenny's iCloud, right?
Well, are you asking me hypothetically, or
Well, you're an expert, so yes, hypothetically.
would I seek somebody else's account?
Right. If you all, there's no, in other words,
If only
there's no
one is
need to go after
encrypted,
the Clenny account,
but not all
then the
parties.
Conversations that they had with her daughter would be memorialized on her iCloud.
The other party should still have it unencrypted.
Okay.
If there's evidence of a felony.
What do you mean?
I mean, I believe one of the reasons for ultimately obtaining the iCloud for the mother and the parent was that there were, I believe, phone calls and text messages.
Wait, are you talking about something that occurred that wasn't, wait, are you talking about the conversation with text message that we have here? That are the subject of the accessing the laptop?
No, you asked me if is it necessary to...
Correct, but you can't just go into someone's iCloud account unless you suspect them of committing a crime first, right?
That's incorrect.
That's incorrect.
Yes.
Please explain that to me.
Is there evidence of a felony?
If there's no evidence of any crime, you can just get a warrant and send it to Apple, and they will give you, for example, my entire iCloud with all my photographs, all of the conversations I've had that are personal to me.
Hypothetically speaking.
Hypothetically, since
If,
we're talking about me.
right. If I were to kill somebody, hypothetically, I never have, for the record.
You got that? Okay.
Hypothetically, if I were to kill somebody,
Yes.
and I were to communicate to you,
Correct.
I just killed so-and-so for X, Y, and Z reason,
Okay.
then we as the police can lawfully obtain a search warrant for your information.
Okay, and I'll
Because
agree
there's
with, well, hold on.
Evidence of a felony, let me finish.
Okay.
Because there's evidence of a felony contained within your records. It doesn't mean that you yourself committed a crime, but there's evidence of a crime.
So your position is that law enforcement, if they have reason to believe that there might be evidence of a crime, might be, not that you have probable cause to believe, that you can then,
Objection, Judge. It's a misstatement of the law, and it's also comporting what is the burden.
Yeah, that's a different standard.
So I think a mistake of what he said,
okay,
so let's,
and I'll clarify. Is it your position that if someone is not suspected of committing a crime, so there's no probable cause to believe they committed a crime?
That's not what I stated.
No, I'm asking. This is a question. Is that your position? That if there's no evidence that they've committed a crime, but you believe that there may be evidence of a separate crime on their phone, that gives you access to their entire phone?
Well, if there is evidence of a crime independent of where it is, evidence specifically of a felony, then we as police can search the premises for that property, for that evidence, whether it's a phone, a residence, a car.
With a warrant.
Or the example that you used, if you say you texted someone, I just killed so-and-so, right?
Correct.
Wouldn't that mean that you only need to get the conversation between the person and the defendant?
No, I disagree with that method of investigation completely.
You are now entitled to their entire iCloud, is what your position with the Miami-Dade Police Department is.
No, my position is that if there is evidence of a felony, then an application for a search warrant can be sought to then search a premises, whether it's a physical premises or electronic.
In terms of an iCloud, if you have reason to believe that there may be evidence of a crime on someone's iCloud, your position is it gives you authority to go through the entire iCloud.
Objection, Judge. I believe he's already answered this now numerous times, and it's also not relevant.
Well,
Kinda
do
is.
you want to use the word parameters somewhere in there? Like, ask it again in a different way, that's a little bit.
Judge is coaching. Crew's the coach.
A little bit clearer as to. I understand, I'm not quite sure he's understood your question quite yet.
When you apply for a search warrant, like in this case, when you applied for the search warrant of Kim and Deborah Clenny, right?
Okay.
There was no,
By the way, and I'm sorry to interrupt. So is this still hypothetical because he was not a part of this?
I'll change it.
Let's change it to the hypothetical.
Okay. So let's say there are defendants.
Going back to
who are
hypotheticals.
parents Of, or not defendants, there are parents who are, their daughter has been accused of a crime, okay? You have now reason to believe that there may be, for example, a communication or something of evidentiary value on the laptop, or not her laptop, on the iCloud, right?
Okay.
Okay? Is it your position that you don't have to state with any particular, I can't even say that word.
Parameter. Particular
do you have to
parameter.
Are you allowed to then go into the entire iCloud? For example, photographs.
Well, depends.
But what you do is a fishing expedition, right? You go look and then determine if there's anything.
Sustain that. There have to be parameters on your.
Parameters is a much easier word for me to say.
She tried to tell you to say it.
It's within the application for the search warrant. There are parameters included within that.
And
the
in
property sought is included within.
And the property sought, for example, did you review the search warrant in this case?
Briefly.
Was it the entirety of the iCloud?
I mean, we could refer to it and go down the list of what it sought, but I believe it was by and large the entirety of the content, yes.
Okay. I have no further questions.
Yes, Judge. Very brief.
There's coffee. If anybody wants coffee, everybody coffee.
Is it normal police practice to inform defendants that are subject of investigation that they are actually the subject of investigation?
Not that I'm aware of. It seems highly inefficient.
And you explained, you said it's highly inefficient. Why is that?
Well, it's not, just to put it briefly, it's not the most efficient or concise way to conduct an investigation, in my opinion.
And now in regards to the information that's provided to you, had you been provided that there were to be some form of filter to these other iClouds, would you have done it?
Yes.
So no malice is what he's establishing here.
Let's ask you if you were made aware of any sort of knowledge of Mr. Kim Clenny being listed in care of Frank Prieto, and were you also aware, and you said no. So does that also mean that you aren't aware that he was listed for the title of that solely for purposes of Phase 2 in the Arthur area?
I don't know specifically. I believe I was made aware, I heard today, that at some point that's when he was listed, but...
And then in regards to Deborah Clenny, have you ever heard any information of when or if she was ever listed?
No, I don't know.
Your Honor, I have no further questions.
Nothing from us, Your Honor.
State you don't have it, this is the article.
Judge, I'd like to, if you don't mind, we can come sidebar to discuss that.
So I think they just said they're doing a sidebar. I don't know if that's it, but maybe I'll have it silent and then it'll cut off, but I'm pretty sure they said sidebar. So, the state attorney you see that just went up in the back corner there to speak to the judge, that is not Attorney Khalil Quinnen. That is someone else who's been in all the other hearings. I haven't seen them pan. I don't know if Quinnen is present, but Quinnen is the subject of a motion. So Jude Facadomo over in the laptop case wrote a motion calling out Khalil Quinnen for prosecutorial misconduct, not just for possibly accessing records that would have been work product, attorney-client privilege between the Clenny family as a whole and Frank Prieto, Sabrina Puglisi, but also that he was sharing, allegedly, the information, personal information, things he found out while reading these communications that that wasn't public knowledge, that hadn't been properly filtered, allegedly, to Daniel Ovale, who was and maybe is still a reporter with the Miami Herald. So, state attorney was speaking to the press. The reason that that could be interesting is back in February of this year, end of January, beginning of February, there was a motion hearing where a gag order was a big subject, a big contentious point, where Frank and Sabrina were like, hey, we have this order to show cause. The state's trying to show cause to get the judge to grant a motion for a protective order, a gag order, to keep the defense attorneys from speaking to the press. Now, you've heard me criticize some of the interviews that these attorneys have done in the press, but they did make a fair point that, if stuff that looks bad for our client is getting out into the media, we have the right and the duty, the fiduciary duty, to defend our client, who is a public figure, in the public eye in response to information against her case that's getting into the media because of the state. They keep alleging it's the state putting it out there. Now, in that motion, they kind of both conceded, all right, well, as long as you're not saying that Christian Obumseli's dad committed SA against Christian Obumseli, and you're not crossing this thin line, it's okay. We're not really seeking a gag order. We're just looking for a very minute constraint that you don't go out and say those things. So it kind of became a moot point at that hearing. The second part of that hearing dealt with a little bit of what we're hearing now, where Sabrina Puglisi asked the judge, like, hey, before we end this hearing today, can we ask the state, can you make them tell you and tell us in open court, are they wiretapping our phones? Are they recording our conversations? Me, Sabrina Puglisi, and Frank Prieto. In other words, are we currently uncharged, but potential parties to what they're charging the trio of Clennys in with the unauthorized access charge with the laptop? And at that hearing, you could see Laura Cruz kind of smirk a little bit, and then the state attorneys, I believe it was Khalil Quinnen, was like, no, there's no wiretaps. But this is still an ongoing issue where it seems like Jude Facadomo, he was the past president of the Florida Criminal Defense Lawyers Association. It has 1,400 members. Those members include Sabrina Puglisi and Frank Prieto. He's been pictured on his website. He has a picture with Sabrina Puglisi. The association put out this press release. I did a video reading it this morning. And he also filed a motion. Now, he's representing the parents, Kim and Deborah. He's not representing Courtney Clenny specifically. Not in this murder trial. But what he's arguing on that wing, that action, over on that case, because remember, this status hearing is about Courtney's murder charge, the murder trial. That's the status hearing for this. But they have to overlap, they necessarily overlap, because what Jude Facadomo is saying, hey, this laptop charge, it should be dismissed. There's prosecutorial misconduct because the state attorney's office went through terabytes and terabytes of data without properly filtering it. And because of that, they were able to see things that were work product and that were protected by attorney-client privilege. And that's why you're hearing in this motion hearing, even though we started in the middle of it, you are hearing over and over. Everything is, oh, so you had no awareness but there's this email to or addressed or from Quinnen, Khalil Quinnen. And you're going to keep hearing the defense try to pin the responsibility on Assistant State Attorney Khalil Quinnen. That's who they're highlighting as the forefront of their grievance. And then Holly, so hey, this technically started at 1:30 p.m. Eastern time. I only got in here at about 4:30, so I was late to the party, about 3 hours. There's no controls for me to rewind, but it's been juicy so far, and we have a Clenny appearance. She looks skinnier. So that's Jude, Frank Prieto, and Sabrina Puglisi. All three of them are going up now. I think Barbara, if you're in the chat still, it looks like she's filled in her brows maybe. The jailhouse makeup request, the product request. And then just a lot of background noise. Hopefully as soon as they pan, we'll unmute it. And I don't want to scroll, but we will go and read. There is some coverage of what happened early on in the morning. I'm not sure if there has been a trial date set, but if this is a pretty contentious dispute over the things that were attorney-client privilege that could impact Courtney Clenny's ability to be represented fairly, to have a fair defense at trial. So I wouldn't be surprised if we don't actually get a trial date set today. And we have to move on to another status hearing sometime in the future. Let's
No more favor. That's what he just said, that he took her out to Joe's program, begging her not to leave. No, I'm okay.
I got you, buddy.
He put a work order right here.
Come on, I'm sorry to bother you. We have an inquiry. Where are you from? Where are you from? That's right. I remember it.
Is it all over?
They're asking where she's from because of her work.
Hell out of here.
Let me go brag.
Does anyone in the chat know what that little thing that this attorney's holding in her hands? What that is? This person who's near wherever the microphone is just like banging their paperwork around. Frank Prieto looks tan.
By the time she gets it.
What's going on?
All right, maybe some action.
All right, everybody.
I just want to lay a record. Oh, am I under?
I got one of those.
Well, I call him first, and then I'll lay the appropriate record.
Your Honor, say we call Frank Prieto to the stand.
And Judge,
Oh!
we've discussed this. Obviously, the attorney-client privilege belongs to the client. I've discussed it with our client, Mr. and Mrs. Clenny.
Frank Prieto!
Do not have an objection subject to certain provisions, that this is not deemed in any way, shape, or form to be a waiver of future attorney-client privilege protection. Further, that any questioning be narrowly tailored. It does not involve Mr. Prieto's impressions, which are protected, or any direct communication. Subject to that parameters, we're okay.
That's Quinnen in the back, sitting there leaning right now. Khalil Quinnen.
Call Mr. Prieto.
All right, so Prieto's coming up.
Yeah,
And-
Judge, if I need to also put on the record that I spoke to my clients, Kim and Deborah Clenny, and for purposes of this hearing, this is a very limited waiver of our attorney-client privilege that we established way back in April 2023.
He's letting us know. He's letting us know.
You're about to give me the truth, the whole truth, nothing but the truth, so help you God?
I do.
To that, Mr. Prieto, good afternoon.
Good afternoon.
In regards to your representation, it began when? And let me be specific to the Clenny parents.
Almost immediately, I believe on the retainer agreement that we executed, it's been introduced into evidence, I believe it was April 6th or 7th, 2022.
Just so I can get that for you. Mr. Prieto, is this in fact a copy of that retainer agreement?
about my reading glasses today.
I think more in mine, but they're very early.
Are they waivers?
They're
Remember, the issue is going to be formal retainer agreement with the parents versus implied, or were we talking about something in furtherance of Courtney Clenny's defense? Because attorney-client privilege has, there's certain things can qualify. So they're going to try to pull apart the dates where there's actually a record of that through a retainer agreement. Whereas Pareto's going to say, no, we had verbal communications, blah, 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 blah. So this is going to be a great, I guarantee it, great direct, great cross, maybe a redirect.
Yes, it is.
All right, just for the record, that's Defense Exhibit A, right?
Yes, correct.
All right, and then in regards to that, so the fact is that you created this representation for the Clenny parents as witnesses, and really whatever is else placed into that agreement.
This agreement was to formalize the agreement that we already had verbally, the scope and limitations of which are constantly changing. As a defense lawyer, when you represent clients, you produce this document. It may or may not say, I believe there's language in here that says included but not limited to X, Y, and Z, because the parameters are always switching as far as the scope of representation.
With that in mind, in regards to the life of Ms. Courtney Clenny's case, you've never informed the state of this agreement of representation with the Clenny parents.
No, there's absolutely no obligation under Florida law or Florida rules of ethics or any kind of rule that I'm aware of in the United States, for that matter, that I have to disclose anything about who my clients are to the government.
And then in regards to the Arthur hearing, do you remember partaking in the Arthur hearing of Ms. Courtney Clenny? And do you remember at some point after the hearing, that day, the 17th, having a conversation with the prosecutors, myself, Mr. Clenny, here in this courtroom?
I can't say a specific recollection because we had a lot of conversations leading up to that date, during that day, so.
Well, let me give you a little bit more.
This is, when was the August 7th?
So it's going to be the 17th was the end of the Arthur hearing. November.
Right. So you said August, but sorry, November 2022.
Well, let the record be clear, I meant November.
Okay.
So in regards to that, do you remember ever being or having this discussion with the prosecutors in regards to potentially having sworn statements taken of the Clenny parents?
I have a vague recollection of something of that nature, but again, I cannot recall the specifics of it. So,
okay.
But yes, I remember that was. I recall something about that, and I don't think it was. I can't remember the terminology that was used. Oh, we wanted to pose them, but clearly, there was no inquiry as to whether I'd represent them.
Well, in regards to that last part of that statement, was there not a request for you to list them as defense witnesses so that if a sworn statement was taken, you could at least be entitled to be present at that sworn statement?
Well, I think they were already listed as state witnesses, which would allow me to be present anyway. So I think that rings a bell. I said that, well, when we cross that bridge, we'll get there, but for now, we're not listing them as defense witnesses in the case in chief.
Right, and so at that point, during that conversation, you didn't disclose that you didn't have to list them. They were, in fact, already your clients.
Correct, they were already my clients, and nothing obligates me to inform you of them.
Right. But again, to that point, though, you didn't inform myself or Mr. Quinn in court that day of this fact.
No, as I do with many clients that are either under investigation or witnesses, I don't disclose the fact I'm representing them. That's the whole nature of the privilege, is that it's privileged. Even the existence of the relationship to a certain extent.
And now since even that hearing and upwards until February 15th, that is the first instance that you disclosed to the state, in fact, that you were representing the Clenny parents as witnesses. Correct.
Once ASA Quinn made the inference that this relationship was falsely created in his pleadings and his statements in his court, I thought it necessary to bring that forward.
And that was the first time, though, that you disclosed to the court, the state, outside of your clients, outside sources, that there was that relationship.
That was the appropriate time to disclose it. Other than that time, it's absolutely not necessary for me to disclose that to anyone.
All right, no further questions. All right, good. Well, one moment.
Oh, I'm sorry.
All right, and I do apologize. I skirted over this topic. There's a point in time, and you were present watching Detective or Sergeant Cremesini's testimony about this email exchange about filtering certain items out of Courtney Clenny's iCloud.
Yes, I did. Yes, I was present.
And at the time of that conversation, you in fact represented the Clenny parents as witnesses.
At the time of what conversation? I'm sorry.
That email exchange with ASA Clenny.
What's the date? I don't
I'm
know.
happy to show it to you.
But I'm happy to look at it.
Yeah.
All right, showing you State's Exhibit 1. Sorry. So the date on here
Sorry, did you want to point something out?
No, I was just going to say, what is the date on the first email that would be on the back, the last page?
Can I skip it home to review
Of
the
course,
entire thing?
of course, no issues.
Yeah, I'm ready. So what was the question?
So my question is, the date of
This
that
would be a
email
conflict of
exchange,
interest.
the first email, what would that date be?
It appeared, I don't know if there was anything prior to this that was either cut off. I have no reason to believe that, but.
Just what's the
first
date?
Here, going back in time, would be September 6, 2022.
2022, September
And
6th.
At least for what is a part of that exhibit, what is the last date? I'm sorry to keep asking you to read, but.
The last date here printed in this particular chain here, again, I don't know if there's more that came after, but Wednesday, September 14, 2022.
All right, and at that point in time, you were representing the Clenny family as witnesses in this total proceeding.
I wouldn't say just witnesses. The retainer agreement speaks for itself. My scope and duties went beyond representing as witnesses. It speaks for itself. I'm not authorized to get into the other details of our attorney-client relationship.
And I'm not asking you to, but simply put, you were representing them in some capacity at the time that these email exchanges took place.
Yes, 100%.
All right, and so as a result of, you were asked by ASA Clinton specifically, what would you like to have filtered out of the iCloud? Is that not correct?
No, that's not correct. I was specifically asked, I believe, if I may reference back to the email. The subject line of the email is not about iCloud or anything. It's Courtney Clenny's cell phone extraction. So these communications are limited to the state's attempts to extract the information from Courtney Clenny's cell phone.
All right, and so in regard specifically to Courtney Clenny's cell phone and that extraction, you didn't inform the court at that point to include both Tim or Deborah Clenny within that filter.
No, I have absolutely no obligation to disclose that. As soon as the state or investigators came across any communications that involve the attorneys on this client's case, they should have stopped and ended their inquiry at that point.
But then here's the question of conversations that didn't include Courtney, conversations that included yourself and Deborah and Kim. You know, you didn't let the state know that there was some sort of agreement for you to, or for them to filter out, at least at that point.
Yeah, it would have nothing to do with them trying to get Courtney's cell phone extraction. And
You can finish, I'm sorry.
no, I'm just, can you just tell me?
I'm
I
muted.
don't understand the scope of your question about the times and the dates that you're talking about.
I think you've answered my question.
Okay.
I don't have any further questions, Jeremy.
So I think strategically he tried to take a very narrow scope about attorney-client privilege, but attorney-client privilege can include more than something
Mr. Priya,
between defense attorney and client directly.
Okay, I just want to talk a little bit first about.
Now, this is Jude Facadomo, who's representing
Let me ask you
the.
first, how long have you been an attorney?
I've been licensed since 2008.
And you practice in state and federal court?
Correct.
And is it your general practice to draft a retainer agreement for your clients?
Yes, absolutely.
Okay, and are you aware that the Florida bar doesn't require a retainer agreement?
No, they don't, absolutely, they absolutely don't. And in fact, I've represented people conditionally without written retainers. I speak to them and let them know, hey, listen, if this develops into something, I'm the man, but clearly giving them legal advice without any kind of written agreement as well.
Well, in that instance, would you be allowed, because you don't have a written retainer agreement, to disclose your communications?
Absolutely not.
Okay, and a retainer agreement, such as the one that you have, which I believe is Defenses A, protects the client, correct?
Yeah.
And protects the lawyer,
It
right?
protects the lawyer and the client. It's best practices to have a written agreement at some point to formalize the relationship.
Okay, and this written agreement was entered on 9/15 of 2022, correct?
That's when I got around to sending it to them
And
in written form. Right.
but that's not when the attorney-client relationship with Kim and Deborah originated, correct?
No, as indicated in the footnote in the retainer, when the incident happened where Courtney, had to defend herself on April 3rd, I met her later that evening in the homicide unit. They interviewed her. I was actually present when they spoke with the Clennys by phone voluntarily. And then Ms. Courtney Clenny was Baker-acted because she was in a very bad place mentally. And so she was Baker-acted. The parents then flew in. I can't remember exactly the date they arrived, but I met with them in my office in Coral Gables to discuss the situation in face-to-face detail because we had obviously many phone conversations. And then I met with them again on April, in person again, on I think April 6th or 7th. I'd have to go back to my text messages, but that is when we all decided that I have very specific clear memories of speaking to them that this, based upon the media attention that was almost immediate, that they're going to need this representation as well to navigate through this.
Was it your understanding that you were their counsel from that date?
Yes.
Okay. And you executed this retainer agreement as a better practice, is that right?
Correct. So just for timeline purposes, we were hopeful the state would not bring charges, which is why this was not written up back in April, even though I was trying to coordinate meetings with the state, and Courtney had been in rehab. She was dealing with PTSD and alcohol issues, and she was in Hawaii in August when the arrest was made, despite us offering to surrender. But and that started, obviously pandemonium on the side of the defense lawyer scrambling to figure out what we're going to do. I assembled our defense team.
So Judge, I don't mean to interject,
And,
but I don't believe this is relevant to our proceedings.
I'll ask you a question, Judge. That's fine. I understand the objection.
More.
I understand.
Sure, sorry.
Come on, Frank.
You can't stop a lawyer from talking.
Did your clients believe their communications with you were confidential?
Of course.
Okay. And you referenced something, but let me ask you this. You're familiar with the rules of the Florida bar, right?
Yes.
Okay, and you're familiar that,
As much as I can.
of course, and you're familiar that Rule 4.1-7 deals with conflicts, correct? Okay. And is it your understanding that a conflict can be waived?
Of course.
And is it your understanding that there's only a conflict of interest if there's diverging interests of the parties?
I mean, it doesn't necessarily have to be, but it can be.
Okay.
They can either be divergent or similarly aligned, and then things can always change. But, so, it's a fluid situation.
But you would agree that one lawyer representing multiple parties is not automatically precluded by the Florida bar?
Absolutely not. It happens all the time in state and federal court, and they conduct Garcia inquiries when that becomes an issue.
Can you tell us what a Garcia hearing is?
Sure, it happens, I think, more so in federal court generally at a first appearance when defendants are scrambling to get representation. There's co-defendants. One lawyer but will sometimes come in and represent the co-defendants for purposes of either the preliminary hearing, and the judge will say, well, you have one lawyer, you guys are co-defendants, there could be a conflict, and he makes the Garcia inquiry to understand that there may be a conflict at some point in the future. And many times the judge may say, if it goes to trial, we're going to need separate counsel. They conduct an inquiry, make sure that the clients make a knowing, intelligent waiver of any potential conflict.
And it's a pretty...
The judge knows it.
Correct.
Okay, and it's an inquiry done by the judge, correct?
Correct.
The government's not part of that, right?
Objection as to relevance.
We had a Garcia hearing today.
Fair enough, Judge, sorry. So, Mr. Prieto, you cross-examined police officers before, right?
Yes.
Okay, and, sometimes they discuss how they only put what's relevant to probable cause in their affidavit, right?
Yes.
Okay, but that doesn't mean
Judge,
that that's
just
all
outside the scope of direct.
Okay.
I'm discussing scope specifically, Judge, and I'll get there. I was just laying some ground. Let's talk about scope of representation, because you mentioned that on Mr. Abeloff's direct. Okay. Scope of representation for a client can change over time, correct?
Yes.
Do you put every possible area that you're going to represent that client on into your retainer agreement?
No, that's impossible.
Okay, so if you have a retainer agreement to represent somebody on, say, a grand theft, and they come in and they say, I just cheated on my wife, are you allowed to tell their wife?
No.
Okay. Why? It's not in your retainer agreement, though.
That's something that they would expect if they were setting confidence to their attorney.
Mr. Abeloff was asking essentially why you didn't tell the state you were representing them. How many clients are you currently representing?
About 20 or 30 at this time.
Okay. And
Ballpark.
do you call the state, short of filing a notice of appearance, do you notify the state of everybody you're representing?
No.
Do you notify the government, the AUSAs, when somebody consults with you?
No, I have currently probably 3 or 4 federal clients that believe they may have indictments, but not sure, and we discussed that, but no, I don't inform the AUSA unless I'm given authority to do so.
And have you ever produced to a state attorney a retainer agreement?
Absolutely not. I can't.
Is that a confidential document?
Yes.
Is it common practice for defense lawyers to disclose their retainer agreements with clients?
No, absolutely not.
Did you ever work for the Miami-Dade State Attorney's Office?
I did.
Did any defense lawyers ever...
You ever receive retainer agreements there?
Judge, I want to ask him if he's ever received a retainer agreement from any of the defense lawyers when he was a prosecutor, relevant to the issue the state raised. I think he's going to say no, Judge, but that's up in the air. I didn't know he was going to be a witness, so I'm ill prepared.
I didn't know either. No, I have not. not to answer that question.
And Mr. Abdullah discussed a conversation you had during the Arthur hearing, correct?
Yes.
Okay. Is it fair to say during the Arthur hearing you were focused on the Arthur hearing?
Yes.
Okay, and during any hearing, whether it's lengthy like this or average length, do you have communications with state attorneys?
Yeah, absolutely.
Do you recall all those communications?
No.
Do you disclose to them at that time who you're representing always?
No, there would be no need to.
If Kim and Deborah Clenny had received a subpoena as was discussed, because the state may have wanted to speak to them, would you have then let them know that you were representing them?
Yeah, I think at that point I'd be obligated to.
Would you show up when they did the questioning?
Yeah, I mean, I'm just, again, it's a hypothetical because it never happened. But at that point, I would probably say, well, I represent them and you can serve me, or we'll arrange for them to come in for deposition, but that's kind of, it never happens.
Did Mr. Quinnan ever ask you if you represent Kim and Deborah Clenny?
No.
Did Mr. Abdullah ever ask you if you represent Kim and Deborah Clenny?
No.
Did Ms. Hogue ever ask you, do you represent Kim and Deborah Clenny? Did anybody in the Miami-Dade State Attorney's Office ask you if you represent Kim and Deborah Clenny?
No.
Had anybody from the Miami-Dade State Attorney's Office asked you, do you represent Kim and Deborah Clenny, what would you have said?
I probably would have said it's none of your business.
Fair enough.
Uh-huh.
If they insisted on proceeding with compulsory process on Kim and Deborah Clenny, would you have then advised them that you represent them?
Yes.
There's been some reference to this July 8th text. Are you familiar with that text?
Yes.
Okay. And that was sent by you, correct?
The hell yeah, that worked? Is that that?
And despite not expressly saying I represent Kim and Deborah Clenny, you did provide, and I believe it is states, actually I think it's a defense exhibit. What are the exhibits? I'm going to show you what's defenses C. This is an email from Judge, I think Mr. Prieto required. And just to speed this along, Mr. Prieto, I'm going to refer you to the second page. There's a list of emails up there. Do you see those?
I do. This is, I apologize, it's the first time I've seen this.
Okay.
But yes, I did.
Is your email listed there?
Yes, it is.
Okay. So it stands to reason that the July 8th text should have been filtered out, even if they didn't believe you represented Kim and Deborah Clenny, correct?
It should have been, and I would just note, for whatever reason, Ms. Puglisi's information was not provided, even though she was co-counsel at the time. It was provided, as I recall, provided in the original email to Quinnan, and Quinnan's email to Cremacini that is left out, it appears to me.
And the substance of, are you familiar with the substance of the messages that are discussed in the warrant? Defenses B.
Those are the ones with respect to the laptop?
Yes.
Yes.
Were those confidential communications?
Yes.
Were those attorney-client communications?
Yes.
Objection, Judge, cause for legal conclusion.
Yes.
He's the attorney here.
Were they communications from you to the client? Yes.
Fair enough. Were they communications to you and your clients?
Yes.
Coach
Are
Cruz.
you an attorney? Oh, wait, we got that. Sorry.
Yes.
Did Kim and Deb believe those were confidential?
Objection, speculation.
Were those communications part of your representation of Kim and Deborah Clenny?
Yes.
1 second. No. Nothing further, Judge.
Good evening, Mr. Prieto. How are you doing?
Good evening.
I'm doing well. Okay, so the email communication that Mr. Aberhoff brought to your attention between you and the state's attorneys, that was discussing the iCloud extraction of Miss Clenny, correct?
No, it was not discussing any iCloud extraction. It was discussing a cell phone extraction, which would have been the Cellbrite program. Most likely, I think there's a couple of programs that can extract this on an iPhone, but it's a cell phone extraction. It's not an iCloud warrant or anything to do with iCloud.
Okay, so, but they basically came to you and asked you to give them information as it related to information that was solely on Courtney Clenny's phone.
That's correct.
You at this point were on zero notice that they were conducting any investigation into your other clients, Kim and Deborah Clenny, right?
Yeah, absolutely. I mean, yes.
Now let me ask you this. When the homicide took place on April 3rd, did Deborah Clenny give a statement to the police? A recorded statement?
Objection as to relevance?
Yes.
I'll get the relevance now. Did you not appear on behalf of Miss Clenny when she was being interviewed by the police
Yes.
as her attorney?
Correct.
Now, and that was all the way in April of 2022.
That's correct.
Now, you had no clue that the state of Florida was attempting to get the iCloud accounts of your other clients, Kim and Deborah, right?
No, I think that didn't happen. Well, that's correct.
You weren't aware, right, that they were no one reached out to you and said, hey, listen, we're gonna go get the iCloud downloads for Kim and Deborah Clenny.
Neither Kim or Deborah Clenny or Courtney Clenny for that matter.
Okay. Did anyone ever ask you, since you had such a good relationship with Miss Clenny's parents, hey, listen, Frank, are you aware of whether or not the Clennys are represented by counsel?
No.
No one ever from the state attorney's office asked you that?
No.
Okay. They didn't even inquire whether or not you knew if they were represented, right?
That's correct.
I think we established already through Mr. Fasciadalmo's questions, at no time did any member of the state's attorney's office ask you directly, are you the lawyer representing Deborah or Kim Clenny?
That's correct.
Okay. No further questions?
We get the state back up.
Mr. If I could have just a quick second.
The yawn. He knows we're laughing at him yawning. He said, all right, keep it together. Such a witness stand pose for a lawyer.
All right, permission to proceed? All right. Having shown the defense, I'm going to show you what's marked for identification purposes as states 1G. Could you please? If you don't mind just taking a quick look at that.
Breathe right over his shoulder.
Yeah, first time I've seen it, but yes.
Correct. So you've never seen this before?
No.
So you just had a chance to read it, though?
I scanned it. Would you like me to read it in more detail?
I would appreciate it.
Sure.
Thank you. So regarding states 1G for identification purposes, have you ever heard of any situations where a defense attorney will file a notice of appearance on behalf of a witness?
Judge, I'm going to check his referencing, and I have not in evidence.
I didn't reference that in my question, Judge.
Well, you just said referencing states 1G.
That's what he just.
I'll reference it.
Okay.
Ask an open question.
Specifically, have you ever heard of a situation or seen a situation where a defense attorney files a notice of appearance on behalf of a witness?
Yes.
And yet you didn't do that here.
No, there's no need to.
And despite the fact that you did not,
Judge.
you wanted to be present if there was ever a question of Deborah or Kim Clenny or a statement taken from them, you expected to be present. That's what you said on the cross.
Well, yes, they were listed as state witnesses, so if you were going to take their deposition, or I was going to take their deposition, I would be present.
And is it you?
This isn't the case against my client, my other client.
Right, but at the point in that, if I wanted to meet with Deborah and Kim Clenny, I didn't have to notice you of that.
I'm sorry, if you wanted to.
Right, if I wanted to go speak to and ask them to come talk to me, I didn't have to go through you. You weren't a listed defense attorney for them, at least on record.
You better answer carefully.
I can, well, you would have had to, or at least you would have been informed of such had you tried to communicate with them directly. They would have.
He answered
But I
carefully.
did not do that because I was never informed of such.
Because I don't have to inform you.
And, you discussed your practice in both state and federal court, and you're quite aware that the state or federal prosecutors will not speak to you or discuss any case or care of witnesses without receiving a notice of representation about specific witnesses.
That's not really how it works.
Really? Could you explain how it works?
It depends on the situation, but I've had many conversations with DEA agents, prosecutors, the U.S. Attorney's Office, agents on the boots on the ground in Central and South America that will openly discuss their targets of their investigations with me, and without having any formal agreement about who I'm representing. A lot of them will take my word for it.
And you want this court to take your word for it as well?
Objection, Your Honor. Move to strike. It's the same.
So now, I'm going to show you, and I'd like to mark this for evidence. Defense is being handed a copy,
I love lawyers against lawyers, guys.
and this is states 1H for identification purposes. I'm showing you, and if defense wants to look at this copy.
You just got a copy.
Judge, before we go down this road, is Mr. Abdullah entering evidence on redirect? It's outside the scope. I mean, I'll let him.
That's why I was saying recross.
We're headed there.
So it's not outside the scope, Your Honor. Specifically, he talked about how this was not the full content of that.
You should have
email
objected
conversation.
sooner, though.
And so we're giving him the full email conversation between himself and Mr. Clenny.
But I want to see it. I want to know.
Showing you the manifestation 1H for identification purposes.
At least he's reading or looking like he's reading. Because sometimes you see people just like hold it and their eyes don't really look at much and then they just go, okay.
Okay. Well, to your understanding and reviewing that, is that not a more complete version or the full version of your or your email conversation with ASA Clenny?
Objection leading.
I'm not trying to splice hairs here, but for whatever reason, there's like 4 signature lines of Ms. Puglisi, which I find odd, but I'd have to go back to my records and search my emails to make sure this is complete. But I've had a ton more communications with ASA Clenny beyond this one, I guess, thread, or however you call it, feed.
Well, to this point, though, is this a fair and accurate depiction of your conversation with ASA Clenny?
As it relates to this once, well, there's multiple topics being discussed, so
Yes.
as this document sits in front of me, I have no reason to doubt that, but I would have to go back and check my records.
So Your Honor, I move stage 1H into evidence.
Judge, our objection is several. First, I'll renew the objection that if he's outside the scope, he's introducing evidence on redirect. I'll remind the court about our sidebar conversation, which was to specifically limit this testimony. Lastly, I'm failing to see what the relevance contained herein is, and perhaps the state can proffer that before they introduce it.
What's additional here that's relevant to?
So, Judge, the next question I would ask him, because the witness mentioned that he found it surprising that Ms. Puglisi wasn't included in this, and the reality is that he never provided her information to have it, at least within this thread or at any point in time, to be excluded from or to be filtered out.
I don't think it's necessary for the purposes of what we're doing with Mr. Bridges, so, we essentially.
Okay, it's like freezing bad.
Yes.
I can
so
hear it,
confirm
though.
I would just still move this into evidence and then move topics.
We'll renew our relevance objection, which I believe the Honor just the same.
I just don't think it's relevant for the purposes of this.
And this is also redirect.
And just to be clear, your representation of the Clennys were solely, or the Clenny family, were solely as potential witnesses in this case throughout the time that there was no agreement or formalized agreement on paper, and then afterwards.
No, it was not limited to just them being potential witnesses. There was a lot of things that I'm not getting into details, but we discussed a lot of potential legal issues that they could be confronted with, and they relied upon my advices.
All right, now we've already read this into the record. In reviewing, if you don't, and I'm sorry to keep asking you to put on glasses. This paragraph here, is there anywhere where glasses?
Yes.
So outside of this paragraph that I'm pointing to, and it looks to be the second full third paragraph from the top, is there anything outside of this, at least within the 4 corners of this document, discussing other representation?
I don't understand the question, but
Well,
discussing, give you,
Right,
what's the scope of the representation that you're asking me?
No, I'm trying to not go beyond what this retainer agreement lays out. Specifically to this paragraph, is there other representation specific to the Clenny family that's not at least laid out here in regarding being a witness?
Objection, Judge Privilege.
Okay. As it relates only to the paragraph of what's in evidence, I'll allow it. Because that is in evidence, correct?
It is, Judge.
Yes.
I think what the state's getting into on redirect is our discussion of what did it go beyond this, which that's one question, but specifics as to what Mr. Prieto was representing the Clennies on, we would think would go outside of what we discussed.
I agree in as much as it goes outside of just what's written here. What was your question again?
My question is just pertaining to this document, the representation outlined here.
And then what's your question?
You know, if it goes, at least here, going beyond being a witness.
Okay, I want that question about what's contained in that document.
I believe that there's lots of other things delineated here that goes beyond advising them solely as potential witnesses in the matter, and in fact, without getting into detail, I did advise them of other items that are not contained in this particular agreement.
Your Honor, if I can just have a brief moment after that. Your Honor, I don't have any further questions.
Nothing, Your Honor. Thank you.
Mr. Chair, just step down.
Yes, Your Honor.
Thank you, Judge.
State you have any other witnesses.
No, Your Honor.
Courtney's all scrunched up over there.
Received argument. I know that it's already 6:10. Go ahead and finish up.
Let's back up.
Everybody okay with that?
We're okay. State's okay.
That's fine, Judge.
Okay. Everybody else okay? All right.
I didn't hear that. Did they say they were okay? I was like, where did the feed go? It cut out and he just appeared at the stand at the podium. I want this feed that they have in the background.
What I want to do it is I want to have the defense go through
Their Zoom
what
feed.
the burden is initially, which is the privilege. State, you can then, I want to hear argument then as to why it is that you believe not only that the relationship didn't exist, but why these communications didn't fall within the purview of like the legal representation itself, not about the fraudulent criminal aspect of it. And then I want to switch over to you telling me why, if I find that it is privileged and that I do believe that it fell within the purview of representation, why it is that it should be excluded from fraud crime. Okay, does that make
Yes,
sense?
Judge. I think that makes sense.
Okay, so just so I'm clear, Your Honor. So Your Honor would like me to begin just by establishing why I believe
Yes.
we've met the burden.
One burden.
Okay, and then State will respond. I'll have an opportunity to rebut their position on that. Okay, so Judge, I can be very quick on the establishment of the attorney-client relationship. It's twofold. First, into evidence, we have defenses A, which is a memorialized retainer agreement between the Prieto law firm, Puglisi Karamis Law, and Kim and Deborah Clenny. This is a memorialization of a previously existing attorney-client relationship. Furthermore, Judge, the state put up their witness, Mr. Prieto, who testified as to the depth of that relationship. I will address the scope after the state deals with that and address their argument, because I understand that's their position. But as the court is aware, and as Mr. Prieto testified to, retainer agreement is a better practice. This is what is preferred by the Florida Bar, but it is not the end-all, be-all of an attorney-client relationship. Per the testimony, per the document that's all right. Per the document that's been introduced as defense's Exhibit A, there was most clearly an attorney-client relationship between Frank Prieto, Sabrina Puglisi, Diane Karamis, and Kim and Deborah Clenny. I don't think it's even in dispute that they represented Ms. Courtney Clenny, although I'll let my co-counsel address that if necessary. So, Judge, these messages that were reviewed, as the evidence has shown the court, were between those attorneys and their clients. So that burden has been far surpassed, and it is now incumbent upon the state to express to the court why they were allowed to pierce that veil.
So, Your Honor, we're not contesting the validity of the agreement, either for Ms. Clenny, Ms. Courtney Clenny, or the parents. Where we challenge it is the extent of the representation. We're at a point in time where they lay out specifically who is a party to at least the Clenny family representation, and then they also lay out the parameters and scopes and duties. At no point in time are we talking about handling evidence or relaying communications from the jail. These type of specific contents and conversations are not a part of this scope and duties, and then we end up, you have to consider, I think to some extent, the argument of crime fraud within it, because at that point the purpose, not from the attorneys, we're not alleging that the attorneys had the intent to commit any crime. And I want that to be clear here. That's not what we're here to do. The reality is that it's the focus and the intent of their clients and how they were using the attorneys. So you were specifically looking at messages from the parents who were asking them to go to their client and receive their client in custody and receive these specific and potential passcodes, and then it's getting relayed back. So we're not saying or alleging that they are part of this criminal conspiracy. We're saying that though they are vessels, they are specific to chain of custody of these passcodes and then of the laptop itself. So within that context, when we're looking to the intent of the Clennys, it's to access the laptop. So I know Your Honor wanted to wait a little bit before we went to crime fraud. I think you have to look at that as part of the context and whether or not it's protected material in furtherance of legal services. And I don't believe at any point we can say that the handling of an item that does not belong to them is part of those legal services.
So, Judge, it seems we've jumped ahead to crime fraud. I just want to be clear that the state's, I don't know if they're abandoning the argument, but my understanding was there was a scope of representation argument. Does the court want me to address that?
I mean, I think essentially they're saying that to perpetuate that these actions, because they are fraudulent, are not within the scope of representation, or just this in general, this hacking, not hacking. Access to the computer is not within the scope of the representation of the claims, is what I'm understanding.
Correct. Okay, so drill down on that, Judge, before I respond. It's not
You're
a,
abandoning any argument.
right, but it's not an argument that your retainer agreement says X and you did Y. It's an argument that your retainer agreement says X, but this was a crime fraud exception. And you were,
So what is the exception that it's not attorney-client privilege? What argument is the state making so I can make my argument back?
Well, let me ask you.
So it's a little bit more.
If it were not what you are alleging to be a crime or a fraud, would you believe that what they are doing with accessing this laptop that was found and the Clenny's apartment is within the scope either of the representation of Mr. and Mrs. Clenny, Deborah Clenny, or within the representation of Kim Clenny? I mean, Courtney Clenny, sorry.
Judge, I hate to ask you to restate that, if you mind.
Putting aside your argument for the moment that these actions constituted a crime or fraud, are you also arguing that trying to access this computer that was found in the apartment and the communications between the parents and these attorneys is outside the scope of either the representation of the Clenny family or the representation of Courtney Clenny in regards to the murder?
And so that's the important thing here, judges, because they are separate entities. They've made it clear by formalizing the retainer agreement. So you have the Clenny family consisting of the parents and their daughter, and then Courtney, so they're separate and apart. So although, yes, they have the same goal of an outcome in the case, they do not require the same representation because they're not co-defendants in that case, in the homicide.
Do you believe it's in the scope of the representation for, let's break it apart, do you believe it's in the scope of the representation for Courtney?
I don't know, Judge, because I don't have a retainer agreement. I would argue no, because still we're getting to this access of an item that does not belong to her, but at the same time, this is the problem here. The moment that the communication, although they want to say it's a defense umbrella, that everyone falls underneath this umbrella, by discussing communications that are privileged within the relationship between Courtney and the attorneys, which is separate from the relationship between the parents and the attorneys. Once they do that, they are piercing that veil themselves. They are violating essentially that attorney-client privilege and having third-party communications. So that's the issue in that representation, is we're getting down to the slope of, as part of her representation, I don't see how the access to really anything outside of her representation would be relevant. And then, so like, let's say the idea of this laptop itself.
You don't think that this is part of her representation?
Well,
That's
so
a long
the issue
note.
comes here that the knowledge component of whose laptop it is comes into play. And so when we sit here of whether or not they're going to access this computer, go through it or anything of that, and they easily could have asked Your Honor, gotten a court order, done any of these proper avenues to go and assist in the further representation of Courtney. Once we start getting into and this is the clear part and why crime fraud is a big deal and why it matters, is that the extent of the representation isn't unlimited. And so once it's who the laptop belongs to, and we're getting down this route of how long they're holding onto the laptop, and we're getting down into accessing the laptop and the procedure of how to do so, I don't believe that we're still within that representation. We're well beyond it.
But from what I'm hearing, because it's intertwined with the fact that they, allegedly didn't have the right to access this laptop. Okay. I don't know, but that's too much to read them.
No, we're fine.
Mr. President.
So, Judge, let me address some issues there. So, first of all, Mr. Avila makes the point of what the defense could have done with this laptop. We're not there. The only reason that laptop exists is because the state breached the privilege. But it raises a good point, and I think Your Honor actually mentioned it earlier, and I think it was certainly more than just a throwaway comment, which is there were many ways for the state to do this. They chose the wrong way to do it, and now they're living with the consequences of it. And the reality is without getting into crime fraud, because I can address that directly, what we have is an attorney-client relationship, the most sacred relationship in law, essentially. And in fact, Judge, it's the state's own case that they cite, and it's U.S. v. Zolan, which is a Supreme Court case, 491 U.S. 554, that says the attorney-client privilege is the oldest confidential communication privilege known in common law. It is a bedrock of what we do here.
This was in his motion to dismiss.
And the state's position that the defense should somehow have done something different with this laptop may be an argument for a future hearing. But it has nothing to do with how we got here. And the way we got here was the state unilaterally deciding, with no effort whatsoever on their part, to determine the nature of the relationship. You heard Detective Perez. He testified that ASA Quinn made the decision there was no attorney-client relationship. That wasn't true. We know that now. that that was not true. We have the evidence of the retainer agreement. We have the testimony of Mr. Prieto. That wasn't true. They didn't make any efforts to contact the attorneys. They didn't make any efforts to contact the Clennys. They didn't bring it to the court's attention, and I'll get to that because that's an issue for the crime fraud exception. They simply unilaterally decided that these communications, which in their own email, which is also in evidence, came from Mr. Prieto. A reasonable prosecutor looking at an attorney, client, or even just an email from an attorney would filter that out. There's been a lot of reference to federal practice. Their DOJ standards for a filter protocol are so comprehensive that the prosecutors handling the case have no idea what's even being reviewed. In this instance, Mr. Quinn reviewed all these messages, decided this needed to be investigated, sent an email or summoned Detective Perez to start an investigation, created what he called a filter protocol, which by the testimony of Sergeant Cremicini was not a filter protocol at all. He even said, no, I didn't think it applied. He just read through the messages. That's the attorney-client privilege that's right there that was breached. Everything after it is fruit of the poisonous tree, Judge. Once they breach that sacred privilege, everything they discover is tainted. They never should have read that. And
I need laser eyes.
Practices than one prosecutor deciding, I don't think there's an attorney-client relationship, review these.
Let me ask you, do you agree that at the time that he is reviewing these text messages that he doesn't know and that the state doesn't know, and nobody knows that there's an attorney-client privilege between anybody and the parent companies?
Very good question, Judge, and let me tell you why. Because
It was in. They're going to say it's in furtherance of Courtney's defense either way.
There was discussion about the search of Michael Haas's home, and there was actually reference to.
That's the contractor, the tech contractor for the law firm Michael Haas.
To let the state know you represent a witness. The reason why that happened is because there is an action by the state that that attorney or that client is made aware of. Had the Clennys been subpoenaed, they would have contacted Mr. Prieto or Ms. Puglisi.
And I don't disagree with the fact that Mr. Prieto doesn't need to tell anybody about the representation, that generally speaking, that's not going to come out until there's some action to disclose that. What I'm asking is that when the state is reviewing this between the parent Clennys and Mr. Prieto, at that time, they don't know that there's an attorney-client privilege there.
Who, the state?
The state.
No, but
You're arguing that they should be filtering that based upon the representation of Courtney Clenny.
No, Judge, based upon the fact that they've been in communication with Mr. Prieto and Ms. Puglisi, not just about Courtney. At that point, they had already discussed with them about Deborah Clenny being on the phone with Courtney at the time of the homicide, that they are well aware that there is an attorney-client relationship, whether they were made aware via a formal retainer agreement or Mr. Prieto saying, yes, I represent them. But Judge, it is...
So your contention is that they were aware that there was an attorney...
I think a reasonable prosecutor would have believed that. But, assuming they don't, in arguendo, Judge, let's say Mr. Quinnan had no idea, right? Fine. He's reviewing these messages. It doesn't make them any less privileged. And if they were going to implement a filter protocol, then that filter protocol should have actually worked instead of, I didn't think it applied. Mr. Quinnan made the unilateral decision that there was no attorney-client privilege.
The filter protocol should have applied for Courtney Clenny's or it should have applied for all of the iCloud, because the filter protocol right now is just for Courtney Clenny. Cell rights what those emails are about, right?
Per their own email, which is, by the way, Mr. Quinnan's email is the state attorney and Miami-Dade Police Department and apparently City of Miami. That is now their filter protocol, that email, because we asked Sergeant Cremicini on the stand what the filter protocol is. It doesn't exist. It's whatever the state tells you to filter out. He told them to filter out Frank Prieto's email.
For Courtney.
No, just in general, Judge.
No, Judge. It was specifically in that email was her phone extraction.
That's what Mr. Prieto said, it was just about Clenny.
Right, Judge, but they had no reason to believe that the parents of a defendant in a second-degree homicide would have their iCloud accounts searched. That's insane, and that's going to be the subject of a separate motion. Had they been made aware, the state would have been made aware of the representation. But I think it's misguided to say, well, if the defense attorney doesn't say to the state attorney, I represent all these people here, that a privilege doesn't
No,
exist.
the privilege exists no matter what. The privilege exists whether they knew about it or not. I'm not saying that the privilege doesn't exist. I'm just asking you whether or not you were saying that you believe that the state actually knew at the time.
I believe.
It's really, ultimately, it's not relevant to my ruling here. I'm just curious. And you don't have to go into it because ultimately it's not relevant. The privilege exists where it doesn't exist.
And the court isn't going to move on misconduct anyway, if there is, if she thinks there is.
Relevant to whether or not the privilege existed.
I agree, Judge, and so I'll be diplomatic. I believe a reasonable prosecutor would have properly inquired. It's very clear that they are acting on their behalf, and certainly worth an inquiry. So I'll leave it at that. But your Honor's point is well taken, that it's not relevant to the privilege. I represent many people that the government and the state is unaware I represent them. That doesn't give me the right to disclose their confidential information. So, Judge, the state's position, I think, is flawed. But also, let's not forget Sergeant Primasini's testimony that he didn't apply the filter protocol to Kim and Deborah. So those messages were just read. The state read through all of those. That privilege is...
Your Honor, that's not evidence. That we read through all of the
That
messages.
that part.
Yeah, I think that
It's in the affidavit that these are...
He said he didn't know what had been read through.
Fair enough. Let me rephrase.
Cited in the affidavit was read.
No, that's fair, Judge. Let me rephrase. His testimony was he did not apply a filter at all to Kim and Deborah Clenny, who we now know were represented. That's where the privilege comes in. And here's the issue with, and I'll go into a little bit of the crime fraud, because I mentioned this earlier, Judge, but the state's relying on this exception, which admittedly exists, but they're relying on a case, American Tobacco, which I have a copy for the court. I think I can pass it up if Your Honor wants to review it, but I'm sure you'll have time. I don't expect the court to rule from the bench. So,
Are we going, am I to make my...
oh, yeah, no, I'm sorry. I thought you had made it already.
I think that I got a little bit sidetracked, but
Go ahead.
All right, just to the point of whether or not, and this is still in the first inquiry, of whether or not it's...
I still have one more question. I'm sorry, because I
Okay.
got sidetracked.
Yes, ma'am.
Do you believe that these conversations that were between the attorneys, the conversations that are referenced in, the search warrant and the affidavit, do you believe that they were not only privileged communications for Kim and Deborah, but also privileged communications within the scope of...
Oh my God, camera guy.
Her murder case?
Yes.
Yeah, that's a better question. So,
Furtherance of
yes,
the murder
on
case.
ballot. So, yeah, Judge, these are all attorney-client. And the state's position that we've opened this unreasonably large umbrella, I think
That's
is...
what I'm saying, it's all this within the umbrella.
Right, but I think that's misguided that we're being unreasonable in the fact that this young lady and her parents and their lawyers might be having communications about representation. And as my colleague just pointed out, Your Honor's going to review the affidavit in evidence. All of these communications are very clearly related to legal principles and evidence and discussing how to proceed in a case. There's no...
In Courtney Clenny's case.
Yes, Judge, but remember, there was no Kim and Deborah Clenny case that they were aware of.
The judge already
How could they
knows.
possibly know that a sealed subpoena was issued to Apple for their iClouds. Had they been, just as the state says, nobody told us you represented them. Had you told us that you had issued a subpoena for iCloud warrants, not only would you have very well been made aware that Ms. Puglisi.
I understand.
Okay. And you certainly would have had it brought before your honor on the breadth of that warrant. But I'll let Mr. Alvarado finish his crime fraud argument.
They haven't really addressed the in furtherance of defense of Courtney Clenny argument. The state has not really addressed that. And I think that's what the judge cares about.
This is where the state still will argue that there is a lack of standing within an expectation. There's no reasonable expectation of privacy within Deborah's messages for Courtney. I understand Your Honors have already ruled on that, but I think Your Honor should, when you're looking at the cases, should reconsider that perspective. That being said, the communications between her and her attorneys, the context of it matters, and the representation for both of them cannot consist of criminal activity. It just can't. And one, it's specifically not mentioned in the Clenny family representation, but I would have to assume that it's not in Courtney's representation as well, because the communications that are subject here are the communications of passcodes and passing them along to the parents, and that is in furtherance of this crime. And so that is why the communications itself, we don't get past, the defense can't meet their burden because they can't show that the intent, or what's clear from those text messages, is the intent to access the laptop, and that is a crime. So that's the issue here, is we don't get to crime fraud because we never get past the conversations being privileged or not.
All right. Any response to that?
I didn't follow that, Judge. How are they not privileged if they're between attorneys and clients?
He's saying that by necessity, well, go ahead.
Well, specifically, the context of the communications, if they're in furtherance of a crime, they can't be legally a part of privileged conversation or privileged communication or presentation.
But that's the crime fraud.
He's saying you don't even have to get to the exception because necessarily they can be part of the representation, is what he's saying. That's
Right.
What
That's what I'm saying. That's what I'm saying.
That would essentially be the crime fraud exception, though. Is that the argument that we're addressing now?
I know we're going to get into that, but I'm saying from a very...
I think the judge is trying to get the state to make a argument about one part at a time, and the state's just missing the ball there.
Because the discussions, as they believe, were related to the commission of a crime, could not be privileged.
Kobe.
Am I getting that right?
Yeah, we're getting that.
Then that's the crime fraud exception, and that's what I was waiting to address.
So let's go into the crime fraud exception.
But let's not characterize that argument as something separate and apart.
I'm saying that it should also be considered in the first part of whether you met your initial burden.
The initial burden was there a attorney-client relationship?
But also if the context or the conversation itself is also protected.
So let me respond by saying this, Judge. Not accepting that there was a crime and that was the purpose of the communications. If we accept the state's position, there was an existing attorney-client relationship well before those communications took place. So the burden of do Frank Prieto and Sabrina Puglisi represent Kim and Deborah Clenny has been set.
I
don't think I dispute that. That they represent them? Right. We're not contesting that there's a relationship created.
Are you then contesting that attorney-client privilege exists?
Yes. Oh, no, not contesting. Not contesting. Not contesting. We're contesting that the context needs to be considered in whether or not they fall outside of the attorney-client privilege.
I don't necessarily see how it is different from this being an exception, but I get, in theory, I get what your argument is. I don't know that it is really different from there being a carve-out exception. I understand you're trying to count in this isn't even part of the representation, but I think that's why it's an exception. But I understand what you're saying.
All right, so and now the burden falls upon the state. If Your Honor does so, in fact, believe the defense has met their burden, that this now falls under one of the caveats to it and the exceptions, and it's under the crime fraud exception. And specific, Judge, it's codified in 90.502 subsection 4 subsection A, that there's no lawyer-client privilege under the section when the services of the lawyer are sought to or obtained to enable or aid anyone to commit or plan to commit what the client knew was a crime or fraud. And that's where we're getting to in these contexts and these specific cases. The cases the state cited to, it's to show that the policy of attorney-client privilege is to promote the administration of justice. Just because there's an agreement, there is no carte blanche as to committing any sort of crime, or communications are all protected if the intent of the client is to commit a crime. And so that's why this exists. We cited to U.S. v. Gordon Nakar, 518 F. 2nd, 972, citing specifically to page 975 of the 5th Circuit, 1975.
Give him a note. Bring him a note.
And it lays out the standards, but it also factually is important. And in that case, that is a communication that takes place at an attorney's office, where a number of people are located at this office, and at some point in time it becomes aware to the state that that conversation was in furtherance to perjure themselves, and those types of communications. And so that information at that point in time made it so that, one, we fell into this caveat. That communication that was had with this attorney was no longer protected, and we're falling into the crime fraud exception. And that's where we are here with this type of case. At the point in time that the communications, and although in that case the attorney knew of the criminal activity, we're not alleging that Mr. Prieto or Ms. Puglisi knew of any criminal activity. They're simply assisting in passing along passcodes to the parents who are in possession of this laptop, and then taking the laptop and handing it off to an IT expert. So within that, that's the only difference, but we fall within that same exact thing where it's the intent of the parties, and that is to commit a crime, and that's access these laptops. And yes, we are citing to American Tobacco. In that specific case, the question was, and really the question was whether or not future crimes were at play. So the facts there were that following a settlement with the co-defendants and on a cigarette lawsuit, it was material was to be provided and then litigated. The court ordered that the material immediately be reviewed by the court, and that's compared here. And the question was whether or not there was a crime fraud exception based off of the purpose behind this litigation, the paperwork. Here, this July 8th message, and this is where we fall into, Mr. Quinn, and the testimony is clear, at least from all the officers, he saw one message, immediately passed it along to them, and the officers, they're able to look through and realize that there's many more messages that are adding to the context of this computer, and it's the criminal act of all accessing this laptop. So what needed to happen was what happened. It's the fact that just because there's a privilege doesn't stop it there at the door and say, okay, criminal activity is allowed to happen. And that's where we get into this crime fraud exception and whether or not it's relevant, important, and something to consider. And the biggest thing about American Tobacco on page 1256 is that the privilege can be lost. That's something that is always needing to be considered by this court. A privilege, even though it exists, can at some point in time, based on the conduct, be lost for the purposes of litigation, for the purposes of criminal conduct. And that's what we have here, Your Honor. That's very specific to this case. It lays out that our burden is nothing more than a prima facie case. It really is probable cause. It's less than probable cause. And the cases that we cited to explain what is the burden, to what extent of what crime fraud actually is. And we find very specifically that, well, what's different in this case is a judge has found probable cause compared to the litany of cases on crime fraud. So we already have a independent administrator, an independent judge reviewing to show that there is probable cause that a crime had been committed.
So, Judge, I want to start rebutting that by making this point, that the attorney-client privilege is not something to try to get around, right? We're not, nobody in this courtroom, and I'll include the state in that, thinks that it has no purpose or no function or isn't vital to what we do every day. So the idea that we're going to try and find a way to circumvent it is upsetting. And I understand the existence of the crime fraud exception. And the reason it doesn't apply here is for several reasons, Judge. First of all, 90.502 provides that there is no attorney-client privilege when the services are sought or obtained to enable or aid someone to commit or plan to commit a crime when the client knew that was crime or fraud. There's been no evidence to suggest that the Clennys had any idea what they were doing was potentially a crime. And I want to say this, Judge, before I get into the argument. There will be forthcoming motions on whether this was a crime. So any argument I'm making here today should not be misinterpreted as us conceding that point, because we don't believe that a crime occurred, period. That's an argument for another day. I think we don't want to get into that now. But let's look at what the state...
I want to get into it.
We breached the privilege. Because we breached the privilege, we were able to find what we think was a crime, which we then further investigated by further breaching the privilege, and therefore effectuated an arrest of these defendants. That falls back on another stalwart of criminal jurisprudence of fruit of the poisonous tree. They had no idea that a laptop existed until they breached the privilege. Also, Judge, by that logic, the state attorney's office would be free to attempt to secure warrants or to search on their own via investigative subpoenas every defense lawyer's email communications with a client because they believe there may be evidence of a future crime. And if they yield a future crime, great, you're under arrest. See, we told you so. If there's no crime that's discovered, nobody's the wiser, no harm, no foul. That's exactly the purpose of the privilege, is to prevent this kind of traipsing through of very sacred attorney-client communications, to create that umbrella that we keep using so that those communications are protected. So the state's position that if we find a crime, it's no harm, no foul, is misguided. They're piercing the veil to try and find this offense. Now let's also remember that the testimony from the stand was incomplete. And it was incomplete because we don't know, and the state, we had shifted the burden to the state. They failed to put up the one witness who was necessary to say, I didn't read any other messages. All we know now is that ASA Quinnen had access to these messages.
They wanted Quinnen up on the stand.
And said, I found this one, start an investigation. That is a prosecutor with the state of Florida reading attorney-client messages secured from the iClouds of these defendants. I don't think there's a clearer picture of a violation of the sacred attorney-client privilege. And the state is asking you to cling to this crime fraud exception, ignoring the fruit of the poisonous tree doctrine, and pushing the court to this very steep precipice of the slippery slope of breaching privilege. Because if this is allowed, the next steps, or I can't even fathom what will happen next. Subpoenas to everybody's iCloud accounts under the suspicion there might be a future crime. We'll be reading through all attorney-client privilege messages in the prosecution and in furtherance of their prosecutions because they believe that they're warranted.
Because I don't mean,
Let's hope that nothing ever goes that far.
I don't mean to object.
That's why we're here, Judge, to ask you.
No, we're going, and at this point, I don't want to cut you off, I'm sorry.
No, please.
The hypotheticals that the defense is imploring here is not reality. What's happened in this case is that there was probable cause found to go in that crime had been committed, going back to the murder, whether evidence was going to be located on the conversations and communications between Ms. Clenny and her mother. So that's how we end up getting into their iClouds, into the warrants, into the phones. That's how we get here. So the issue here is, without proper knowledge, the state at this point, all the way through, is acting in good faith. We're preparing our case. We're looking to the evidence. Defense, in the manner in which I understood their argument, is we're not to look. We have to hypothetically believe that an attorney-client privilege had to have existed under these circumstances, and then not look through evidence, because there had to have been one based off of how this case has gone. And that's just one that's unfair, it's unrealistic, and that's not what happens in criminal cases. At the end of the day, we sat here in a moment where the only testimony that's before Your Honor is that this detective was informed that ASA Quinnen found one message, stopped looking at it, provided him all of this evidence, and told him, hey, go look at this, do your own analysis. And there's nothing else in front of this record. So for defense to say that, one, reference ASA Quinnen, and then go on this laundry list of hypotheticals, we're stretching. We're going way too far. And that's just not what this case is. It's not what's here before Your Honor. At the end of the day, Your Honor, it's future crime violations. We get to this point in time of what is protected material, and certainly so. If the state was aware at the time that this attorney-client privilege existed, it's not being reviewed. It's getting redacted out. But what's ending up happening is, without any sort of knowledge, the state can only proceed as they can in good faith in looking at this material. And when a questionable issue arises, it's how do you handle it? And so in this instance, because we're already into this crime fraud, that very first message, that July 8th message that is reviewed by ASA Quinnen, is very specific that there's a laptop from Agumseli, suspected Agumseli laptop, that is now, the question is whether or not someone is going to be passing along passcodes to get access to this laptop. That alone is now alleging, it is a, it's a conspiracy, it's a solicitation, it is already the beginning of a crime. That is that communication, that message itself is the beginning of, all right, well, where are we going with this? And so that's the issue, is that we get to the very first message, and it's already allegations that could be made a probable cause of a crime being committed. So that's why if you get this investigation that takes place, that happens this way. So the issue here that I have personally is that defense is saying the state's not acting in good faith. Throughout this whole time of how we're evaluating the case and how we're looking at the evidence with the knowledge known to us, we're doing what we can with that and ciphering through it. When we end up finding out there is a privilege, the only time we're finding out is February 15th. So at that point in time, the investigation's already completed, the arrests have already been made, and the question was, now it's whether there was a privilege or not. Was it privileged communications? And are we in crime fraud? And that is, these communications are future crimes.
So, Judge, a couple of points. First, Mr. Aldoff said that if they did find something that was attorney-client privilege, it would be filtered out and they wouldn't review it. That's not what happened with them. That's not what the testimony was. Secondly, the state just said that this was a conspiracy, and well, I don't know. I saw from the table the word conspiracy now.
Why not use the word conspiracy by not letting the
Fair enough. I'll move along so that I think the court understands our concern with that. But Judge, this is not hypothetical, as my colleague says. This is very real, and let's talk about what these facts are. Ms. Courtney Clenny was charged with a second-degree murder, right? We all agree with, and the theory of the state's prosecution is this is a heat-of-the-moment situation. I don't think it's any secret that the defense, this position is this is self-defense. That's what the state's investigating. Because Mr. Clenny testified at the Arthur hearing, the state sought a warrant including some material misrepresentations and omissions that got Mr. Clenny's iCloud account and Miss Clenny's iCloud account. That is not standard practice, and I understand that it was executed by a judge, and that's going to be another issue, but we're not talking about hypotheticals. Had any of the defense lawyers who represent the Clennys been aware of this overreach, they would have certainly addressed it. So these are not hypotheticals. There was no reason for the defense team to be making the state aware of their representation until they were aware there was action being taken against their clients. Nobody would have ever suspected that. That's insane behavior. So, Judge, this... Sorry, the rhetoric. Sorry, Judge. Okay, fair enough. But Judge, let me point to the state's case, and I started to reference it earlier, but the American Tobacco case is relevant because I'm going to go ahead and disagree with my colleague that it discussed a future crime. It was a lawsuit by the state against the tobacco companies for knowingly misleading the public as to the danger of the product. That's as past crime as possible. It was a request by the state to seek discovery evidence from a different defense team that had a joint defense agreement as to communications with the current defense team and their strategy. The reason why that's important is because it had a hearing. That's where this prima facie showing that the state is relying on comes up. It was brought before the judge for an in-camera review, and then each side was offered the opportunity to address the court and say, this is why it's not crime fraud. Instead, the state unilaterally decided, this is crime fraud, there's no attorney-client relationship, but if there is, it doesn't apply. Those were all decisions made within the state attorney's office, with no outside counsel, without implementing a meaningful filter protocol, without contacting the Florida bar, without bringing the matter before Your Honor for an in-camera review.
All the interested stuff happened privately with the judge.
Which means appearance. So it'd be difficult to have that hearing because it's all been done.
So let me ask you this then, Judge. Why impose a filter protocol?
My understanding is the filter protocol was only for Courtney.
Right.
Okay, but it was for Frank Prieto's emails, and these are emails with Frank Prieto. There's nothing in that email that's been introduced into evidence that says this is just for Courtney.
My understanding, and you guys can correct me if I'm wrong, is those filter protocols were only for that initial phone extraction for Courtney.
That's correct.
And then that phone wasn't able to be extracted because it was encrypted. At some point in time, Officer Clenny finds a photograph somehow on the phone that so is there I'm sorry. So at some point in time, Officer Clenny finds a photograph on there that allegedly, or that is a passcode for her phone. They're able to then go into the phone, but that these are iCloud requests for iClouds that were separate from Courtney Clenny that were based on, for whatever reason, and that is again a separate issue, for whatever reason the state decided they want these warrants for these iClouds, and that the iClouds for the parents are the ones that there's no filter protocol put in place because at that point in time they don't know that there is an attorney-client privilege. Had they known that there was an attorney-client privilege, hopefully they wouldn't have done this, and then they could have come to me to say, let's have a hearing, this is a crime fraud exception. But they didn't do that because they didn't know, so we're at this point, which is after everything has already happened.
So, Judge, in response to that,
Correct.
and
Is there
I
something
would
factually
ask-
that you disagree with it after that?
yes, Judge, and I'll tell you why. And in evidence, you have the arrest warrant.
I do.
All of that is negated by the first paragraph of page 5. It is very clear from that they are aware that there is a potential issue with attorney-client relationship with Kim and Deborah Clenny because they address it. They just got it wrong, and they got it.
Tell me.
Okay, so, Your Honor, and to be clear, this is Detective Perez's affidavit, but he testified he got the legal principles from the state. Okay? So we're looking at the page, top of page 5. It actually starts on page 4, Judge. Contained within subject 3's iCloud warrants were returns backed up from her phone. Of pertinence here.
So that's Clenny, Courtney Clenny.
Included subject 2, Frank Andrew Prieto, Sabrina Puglisi, Manuel Reco, Pam Corvalon, and individuals 1, 2, 3, and 4 represent subject 1 in her underlying case. Subjects 1, 2, and 3 are not clients of individuals 1, 2, 3, or 4 as defined by this statute. Subjects 2 and 3, as listed witnesses, were subject to legal process and therefore could not be represented by individuals 1, 2, 3, or 4. Accordingly, there is no attorney-client privilege contained within the messages. Additionally, because the conversation sought, obtained to enable or aid the commission of crime, there is no attorney-client privilege conversation. This paragraph, Judge, negates the position that we didn't know and we didn't consider it. It is in the warrant. They discussed it, and that was the testimony. He discussed it with Detective Perez. They went to the lengths to outline why it did not apply and presented some of these misrepresentations to a judge. They knew.
So, and Judge, just to
I
that,
had not considered that.
and just for clarity purposes, what was never asked of this detective was whether that was in reference to the attorney-client privilege with Courtney Clenny. So, in regards to that attorney-client privilege in general, this has nothing, the question of attorney-client privilege in this point in time of the detective, the question of whether the only privilege we're aware of was between Courtney and her attorneys. So the issue here is whether or not these communications included Courtney or were any in furtherance of these types of things. So that's the issue here. Plus, in regards to knowledge of subjects 2 and 3 are not clients of individuals 1, 2, 3, or 4, that is what's specifically laid out because there was nothing before the state or the court or any court about their representation of both Kim and Deborah Clenny. And so that's why that's in there as well, Judge. It's specifically saying that there is no knowledge of any sort of relationship at that point.
And it's interesting because defense wants to infer knowledge from the same thing.
And I think, Judge, again, I'm going to have to correct my colleague or disagree. This does not pertain to representation of Courtney Clenny, and Your Honor will have the luxury of reviewing it, and I pointed the court to where we think it speaks to discussions. It is discussions about the representation or their determination that there was none. And as Your Honor said earlier, there were other ways to do it. This was a decision that they made. This was a theory that they put forth, and now they live with the consequences. I think. Oh,
Your Honor, are you going to hear a separate argument as it relates to Courtney Clenny?
Yes, but I wanted to hear from Mr. Pachadomo also about why he believes that this would not. You said that, I think we got sidetracked. Were you done with your argument about why you believe that this does not fall within subsection 4A?
The crime fraud?
Yeah.
Let me bullet point. So under First Union National Bank versus Whitler, that's 715 Southern 2nd, 971, at 984, sorry. That's what discusses the clients needing to know that they were in the commission of a crime. Secondly, Judge, the only way the state was aware of the laptop was by breaching the privilege. So I think, again, the doctrine of the fruit of the poisonous tree would be applicable there because there was no knowledge of any of this until they breached that privilege. And lastly, Judge, let's talk about what the crime they're alleging is. A laptop that was left by a crime scene at a unit that belonged equally to Ms. Clenny, more so, I would argue, but that's a different issue. Mr. Clenny is alleged to have taken all the property from there and stored it. The laptop was found. Defense counsel, and this is the state's position, in light most favorable to the state, what they're alleging is defense counsel then communicates with their client to investigate a item that they think might be relevant to the case. And the Florida bar rules are very clear. If they had discovered something on that laptop that had evidentiary value, they would have been compelled to produce it in a certain fashion to the court under some sort of privilege for Your Honor to review, produce it in discovery. What we have is defense lawyers doing what defense lawyers do, which is represent their client and investigate cases. The notion that the state attorney's office are the only ones allowed to investigate their case, especially on an item that's been discarded by law enforcement, and that if we find it, we have to ask pretty please, can we now look at this? That's misguided. There's no crime here. So meeting that prima facie showing of a criminal offense, we haven't gotten there. And again, Your Honor, that is subject to another motion, and I don't want to get too far ahead of ourselves because, frankly, I don't know that we're going to need to. But again, those are our arguments with regard to the crime fraud exemption.
Small little addition.
I don't want you to address something from you, but go ahead.
All right, so it's not only what is charged, but it's a prima facie case of criminal activity. So yes, they've been charged with accessing this laptop, but there's also a grand theft that a prima facie case has been met. That there's no crime of, let's say they take all these items, put into storage, don't know about it. The moment in time they know that it's a suspected Abu Sali laptop, and once they certainly get access to it and realize it's an Abu Sali laptop because his birthday is the way they get into it, now we're talking about grand theft when they continue to hold this and withhold this from the family. The only other thing I'd add is, I mean, listen, discarded from law enforcement, those officers are looking through this criminal scene, trying to figure out whatever's important.
I'm not too worried about. I'm pretty hung up on the part of this that says that the client knew that it was a crime or fraud. It could have just said, the legislator could have just said that the client committed a crime or fraud. But they say that they knew that it was a crime or fraud. And I get that you're saying that there's no conspiracy. But if the attorneys don't know, how are the clients going to know?
So the issue here, Judge,
I mean, what evidence do you have that they knew?
so it's not that it's, so the fact of whose laptop it is and accessing it in and of itself, there are plenty of crimes you don't know are crimes that could happen. I mean, at the end of the day,
And that's different. That's, knowledge, lack of knowledge of the law
it's not a defense.
is not defense. But this is different.
So to that specific instance, Your Honor, if you give me 1 second, I'm going to look at one thing on a computer.
Because I think that this language is very specific. It's not just the commission.
And Judge, we appreciate that they don't want to use the word conspiracy. Sorry.
Your Honor, I do believe, and I'm going to try and pull this up just to have an answer at some point in this hearing for that. But again, I think it's going to come down to ignorance of the law is not a defense.
Not a defense to a crime.
Correct. But
But
when
I
it,
think that it might be a defense to this.
to crime fraud.
Yes.
And so, Your Honor, that's the issue is, now we're talking, again, that's why, even if Your Honor finds that there's an issue as to accessing this laptop, it's certainly a crime of withholding this laptop from the family, withholding the laptop, keeping it within their possession. And that's why there is a prima facie case for that too. I'm going to try and get an answer and do a little bit more as to your issues, but I do believe that for crime fraud itself, it's inherent that, in just common sense, if you're trying to access someone else's computer that you don't have authorization for, that's the issue, Judge. It's the intent to access that laptop. It goes hand in hand with that ignorance is not a defense.
Okay.
Judge, just briefly, Your Honor has the warrant. You can refer to the messages. It's very clear that these are discussions with counsel about how to proceed and also how to proceed carefully and in accordance with the rules of ethics. So to then impart knowledge of criminal activity, willfulness, or intent to the Clennys is misguided. That can't be established. Let's also not forget, Judge, that my argument was made in the light most favorable to the state's position. There was testimony from the stand that nobody knows what actually happened, that these messages are in a vacuum, which is another issue of a corpus delicti, or whether there was a criminal act here, even if we take the state's representation and impart intent. Nobody knows what sought access, nobody knows whose laptop it was. They're just inferring, to use Detective Perez's phrase, which is just not enough.
So, again, the issue of whether this is a crime is separate. It may very well be a crime, and you may very well have the evidence of it being a crime, but that is separate and apart from me finding whether or not this is a carved out exception under this language for the privilege. Like, they're two separate knowledges. Whether you can prove the crime is one thing versus whether or not you can prove this as an exception. Go ahead. What do you have there?
That's a good question.
Yeah, there's got to be like pretty limited case law on this, just situationally.
I just request that Your Honor is going to take the time to review all of
You
this.
can brief me, that's fine. I will tell you right now, and I'll be very upfront that I am hung up on this.
Yes, Judge. We'll brief you.
Sorry, Judge.
Oh, no,
Come on. More briefs?
Saves me from doing the research myself.
Fair enough, Judge. I think we've killed enough forests on this case,
Don't
Judge.
send it via paper. All right, so yes, all right.
Yeah, definitely not going to get a trial date if they are like,
Okay,
please
so
give me
we're
more
just
briefs.
focusing now on Miss Courtney Clenny and her team, okay?
Yes.
Now, first of all, I know the court had asked a question of whether or not they knew that the Clennys were represented, okay? The parent Clenny. Parent Clennys, I think that's right. Anyway, so Judge, it's going to be so late. So Judge, first I want to make it clear that the evidence was presented to Your Honor was, number one, Mr. Prieto appeared on Deborah Clenny's behalf on the day she was first interviewed by detectives, okay? Then, Kim Clenny was listed in care of Frank Prieto, law firm, for the offer. There was all these communications. So for the state to come now and try to argue willful blindness without even asking is what the problem is. I would say that they were on some notice that there was some form of legal representation by Frank Prieto and the parents. To come back now and say, oh, well, we weren't sure. And one thing that's very telling to me, Judge, that I know that there was a concern in their office that this was attorney-client privilege. If they were so confident it wasn't, why not read the whole conversation? Why stop at just the one message and send it to someone else and go, I'm not going to read anything else? If you truly believed that there was no problem and it wasn't protected, then read the whole thing. Why are you sending it to someone else?
I think at that point you're sending it as an investigation of crime.
But at the same time, Judge, nothing prevents them if in their mind there's no attorney-client issue here. Read the whole thing. You don't then go and send that one message and one message alone to be investigated. Okay? So that is very telling on the part of the state that there was at least that suspicion. And that is where their responsibility comes in. Your Honor, I've handled a very specific high-profile case, and in that case, what the State's Attorney's Office did when they did a dump on a person's phone, the moment they saw my name, they sent everything to a different State Attorney's Office for filtration, and had a different State Attorney's Office review because they didn't want any of the local police department who was working with them to become privy to this conversation. They're not, we all know what the constructive knowledge law is in terms of when it comes to police officers and state attorneys. They can't come in here when we're arguing discovery violations and go, well, the detective didn't tell me about it. We know the case law is clear. Whatever is in their constructive knowledge is in the knowledge of the state. They are an arm of the state, Judge. So now focusing more on Courtney Clenny. So what's very interesting here, Judge, is there's zero mention of work product. Zero mention by the state of Florida. We all know that they know what work product is because they deal with it on a daily basis. Now, the emails that they sought to introduce that involved Mr. Prieto and Ms. Puglisi, when they're discussing whether or not the investigator should be included in this, you will be able to read yourself that Mr. Clenny was of the proposition that an investigator with the defense team isn't underprivileged. That was what his proposition on the law was. And Ms. Puglisi had to write back and go, no, look at work product. So she took the active step of letting them know, hey, listen, there's a much broader umbrella when it comes to it's not just the lawyers and the attorneys. Now, of course, it's not on the defense to educate the state attorneys on what attorney-client privilege is. They have Westlaw, they can call the Florida bar. But the issue I have, Judge, here is you have a state attorney, A.S.A. Clenney, who in all of his pleadings purports to be somewhat of an expert. I was brought onto this case because of my knowledge in digital evidence. You get this done, and you try to say, I inadvertently was checking the body first of those messages. As an attorney in this level of expertise, what he should have done was check first who the parties to the conversation was. The moment that he saw that Frank Prieto and Sabrina Puglisi, their paralegal, their investigator, were in that chat, everything should have stopped.
I think the judge is inclined to agree here.
To the court's attention and said, listen, Judge, I'm not sure, I don't know, or at the very least, Your Honor, make a phone call. We're all professionals. We all communicate. But is this going to be where I didn't want to put them on notice? Because then that's leading to the argument that you think the lawyers are going to engage in some kind of criminal activity. We all do this every single day in this courthouse where we communicate with one another. But they were purposely trying to keep this from the Clenny defense team, that they were getting this iCloud account. Now, if they had done any research on work product, Judge, that case with Rabin deals with the attorney, Sam Rabin, interviewing a witness for the representation of his client. Very clear that they said that communication was privileged, okay? Now, that person ended up waiving the privilege. So then he went into and raised the privilege on his own, saying, I'm now, Judge, this is a problem. That communication contains my mental impressions, my opinions. So now it's no longer fact work product, it goes to opinion work product. And the case law is clear that that almost is as privileged, it says, if not the same, I think is the language, as attorney-client privilege. Because it is detailing all of the strategy. And if you look at the conversation, Judge, I think Mr. Prieto made a representation when he was Mr. Prieto. Mr. Abelhoff made a representation in his argument that the Clennys were getting the attorney to get the passcode. That's not what happened, Judge. If you read the text messages yourself, it's literally, it came to light that they were in possession of it, and the attorneys are asking, okay, let's see if I can get you guys a passcode. Your Honor, we're all criminal defense attorneys. I mean, the collective experience amongst the defense team alone is in the decades. This detective himself told you, in his 5 years, he has never seen this crime charge. I, in my many years in this building, as being a public defender and assistant regional counsel practicing only criminal defense, I have never seen the state attorney's office bring this charge. I would never know, as neither did they, that this was some sort of criminal activity. Otherwise, they would have advised them differently, Judge.
That's what I don't know as well.
And how we know that, Judge, is because if there was criminal intent, they would have, you wouldn't have those language of saying, do not access anything on that laptop. Okay, you've got the code, that's fine. It will make things easier. Just like how Sergeant Cremsini said, things became easier in searching her iCloud, Courtney Clenny, when they had the passcode. So that all that meant was, oh, we have the passcode, it's going to make everything easy for our IT person to clone the contents of that laptop. And you have to remember, Judge, at this time, number one, they don't even know it's Abu Sadi's laptop. Courtney Clenny is in custody, okay? So she has no idea of what's going on outside. This is literally the defense attorneys conducting their investigation, asking in their capacity of their representation to have the Clennys who were in possession of this unknown owner laptop, doesn't even know if it's really their daughters who probably bought it, to say, hey, listen, we need to find out what this is. Use this password and try to get in. There is nothing in the language of anything from any of those communications, Judge, that evidence any criminal intent of any, or reference anything of any wrongdoing. This guessing of the passwords thing, all that shows you is someone might have a bad memory. For the state to argue that, you know, oh, you can't remember this passcode, or for them to stand here and say you going into someone's phone without their permission is per se, without knowing you're not supposed to, I would say that makes that statute unconstitutional.
Well, that's a whole other.
That's a whole different day, whole other argument, everything. But Your Honor,
I'm very much hung up on the fact that I don't think that anybody here knew that this was against the law before right now in this case, except for maybe Mr. Clenney.
and I didn't know, Judge.
And I can't imagine that these attorneys are going to be advising their clients to do something illegal. So I'm just proffering and so in the context of this statute, you know, in this exception, the knowledge part, I'm finding problematic.
Judge, I don't mean to interrupt.
And Your Honor, just because I know Mr. Abeloff also brought up, oh, well, there's something here about gram theft. The element in gram theft would mean that the person has to know they're not allowed to take the property. All of that is lacking here because this was literally released to the family.
I mean, I'm also not making any inference. The state knew that the Clenny parents were represented. I don't think that either.
Yeah.
So putting that out there, it doesn't, you know, that is irrelevant as to whether, you know, the attorney-client privilege existed. But I also don't believe that. So.
And Your Honor, so I think the evidence is patently clear. It's clear to this court, it's clear on the record, it's clear to the evidence that this is protected work product doctrine because they were literally acting in their capacity of trying to investigate the defense of Miss Courtney Clenny. So I know the court was inquiring as to, oh, well, what was the intent of this conversation? Part of the intent was, number one, they're witnesses and they're represented by them. But it's clear that the intent is purely investigative of what they
This
were
is the argument I think the state should have made and didn't.
work product. And Your Honor, why that's also very concerning is there were discussions about their strategy in there. The state, as you already articulated, that I don't know or I didn't know isn't a defense. It's once you know, you know. The two faces out of the two. Unfortunately, even if you found this out inadvertently, once you know, you know. So you guys went ahead and, like Mr. Fasherdamo said, without any steps to determine whether or not if this is privileged or not, decided to go ahead and pierce that veil and read it. And Judge, that's what is concerning here.
Determining whether or not it was privileged under work product privilege for
Yes, they didn't even take that into a consideration, Judge, and it's not something that they can go, I don't know about that, because we are inundated with, oh, that's work product, you can't get our pre-file conference notes. So they know. And you know what? Their lawyers in the state of Florida, they are tasked with knowing that. You can't come in here and go, oh, I didn't know. That would be like a police officer going, I didn't know I was supposed to get a warrant. It's not a defense. So their knowledge of the attorney-client privilege doesn't take away from the argument. But what they did know, Judge, when they saw those names,
Furtherance of defense of Courtney
Clenny,
Clenny.
known that it was work product, and then the steps should have been taken. They unilaterally decided that because it was defense witnesses that were present in this conversation, that sound made it unprivileged, and that's not true. Had they done a minuscule of research on work product doctrine and attorneys talking to defense witnesses, or attorneys utilizing people to help conduct their investigation. So that's where it falls under that. And Judge, just going straight into the crime fraud exception, I still haven't heard from the state what evidence they have. I know they believe that this was a crime that was being committed. But if we don't have the contents of the conversation, what evidence do you have that there was a crime? Because the case law is absolutely clear. They keep arguing the contents of the conversation means it shows that they were going into a laptop that they didn't know was there. Take that out of it, because that's what the case law says. You cannot use the communication at issue to establish the fraud. So take that out of it, and what's left? Nothing. Absolutely nothing. If they're going to come in here and say, well, Judge, we have evidence that a computer was accessed. By who? Without the conversation. What else? How do you know they didn't have permission without the conversation? I mean, it's actually in the conversation that they didn't know who the laptop was, but taking that out of it, all they have is a report from an expert on the laptop that says, I can say that it was accessed. If the state is going to come in here and make the argument and proposition that when someone passes away, all consent and ownership should automatically cease, and no one is allowed to get anything, because then that would mean that any friends of theirs that had picked up Obumseli's property would have been guilty of grand theft. And nothing, they make this representation, well, you know, they were holding this against the will of the Obumseli family. What evidence before this court is that they even knew the laptop existed or asked for it? That'd be something different, Judge.
Yeah, she's spitting.
No one knew about this laptop until they pierced that veil of an attorney-client work product protected conversation. And they're the ones that are putting the cart before the horse. You can't pierce the veil, get the conversation, and then try to argue, well, now I have the conversation. It's exactly what Mr. Fasciadamo said. I've never seen a case, I researched every single case in the state of Florida as it pertains to attorney-client privilege. And I haven't found one case where there's a retainer agreement in place, and then they're trying to argue that any communication is invalid. Most of the time is the state becomes aware that there may be a conversation, and subpoena, and then the proper procedure is followed. And this is just a very weird set of circumstances, Judge, and the evolving of technology today as it is with phones and iClouds and all those things that they contain. But our position is the moment, Judge, that they saw her, I think the text message was called Team Clenny, was the name of the group chat. Defense Team Clenny. Not defense, but I think it was Team Clenny. But that alone is letting them know, Judge, and they should have taken the steps at that moment. You can't come in here and be willfully blind and go, oh, well, I just assumed that there were. It doesn't work that way, Judge, because then that would be the excuse anytime a state attorney comes in here to try and argue, well, I didn't know that was his attorney. I didn't know that they were talking. It doesn't work that way, Judge. That's why I would say it's a strict liability analysis. So.
All right, last word on this particular issue.
So just
Crime fraud.
specifically for crime fraud in regards to work product, it's the state's argument that this is in fact contents, not opinion. And that's the context of it. You'll have to look at the warrants and you'll be able to make your own determination. One is less protected than the other one, but when it comes down to either, we start getting into the crime fraud exception as to the actual communications, and that's American Tobacco, that's the Black case, that's Nagar case, and we sit here in this moment and point in time where there is no exception or excuse for the contents of it. Certainly we're going to brief Your Honor the issue of that intent that Your Honor is hung up on, but you know, that's where this is at. The defense talks about the grand theft and any friend would have been guilty if they took his computer. Yeah, if they kept his computer and withheld it and didn't give it back to the family, no, like that's the issue, is that's where we come here, and that's the secondary crime of this. If you take somebody's property, deceased or not, it's a grand theft. So that is the reality of that circumstance. The question of what should have been done, the policy arguments that defense brings up, I don't think really at this point, I think it's clear Your Honor has made the right assessment here that the question of whether or not the attorneys knew it was a crime and whether or not the prosecutors knew there was an actual privilege, I think everyone is here acting in good faith in that regard, but we come to this point in time of whether or not those communications and the intent of the Clennys were to access that computer. And that's where that was. That's where these communications, and Your Honor, it's before you there, you'll see that their intent is to get into that computer, and work product, which has less protection than attorney-client privilege, still falls in line with this crime fraud exception. And we still get into this issue of that it's negated by the intent of the Clenny family.
All right, I don't think I need to hear any more. Does anybody have anything else that they feel that they need to say? Right on our 6-hour point? No? All right, so I think that we're done for the day. Marvin?
Obviously, no trial date's going to be set.
Yes, and office closed, so I have to come back tomorrow. Assuming I can come back.
Just give me a 1 second, please. Very right, I'm not going to do any sort of
court staff for enduring with us, especially corrections. Thank you. Thank you.
And they know that I don't stay late with these, so.
Your Honor, the other motion that you wanted to address today, I don't think we need to address that right now, Judge, because I think that the state, through Ms. Solomon, who's been above board here, has delayed providing the Chapter 190 documents to, I think it was WPLG. She's delayed it based upon our filing of the motion for protective order, so they're not going to turn that over until there's a ruling on that, so I don't think we need to address it. Not to mention, there's an issue of the specificity of the file names. I don't have them, so I just listed the actual request that was made, which was very broad. So by the time you reset that, I should have the specific file names to say these are the ones we're seeking.
Yeah, so they're talking about a protective order, guys, for public records.
Sure. Yep, let's do
Oh, oh, we're losing the feed.
Judge, just
We can still hear it, though.
time before the briefing.
There we go. Off the record. So it sounds like that last thing they're discussing, and it makes sense they're going off the record, is because they said Chapter 119, that's public records, so they're probably talking about specific things that they still need to have the judge make a ruling on, that they don't want to become public records that the media and people like us can get our eyes on. Yeah, so I was hoping that when this ended, I'd be able to refresh the window. But it's still technically running, just quiet here. Maybe it'll come back after they talk about this. But when this is all done, if I can refresh this window, and... Are we back? They're cutting it? Alright. Let's refresh and see if it starts from the beginning. I don't think it will. But... what we'll do is if we can see the beginning, we'll figure out what to do with that, because that would be about 3 hours worth, guys, because it started at 1:30 and this stream started at about 4:30. So there'd be 3 hours. But we'll get through these articles. I have 2 articles pulled up where people recapped the beginning, some of the stuff that we missed. But overall, I think the state was pretty weak on oral arguments, but better at questioning when the witnesses were on the stand. Oh, what are we doing? Come on, feed. If I keep refreshing it, will it will it keep giving me a little clip? I'm gonna do it one more time. I do think the state was better with some of the questions to the witness. So the guy that was in charge of filtering the evidence before the prosecutor was supposed to be able to see it, and also with Frank Prieto. But I think both Fasciadomo and Cara, I think is her name, if Miranda was referring to her, I think their oral arguments were better. I don't think Cara really delivered her oral arguments well at first, but she really came in the end and focused on that one argument the judge seemed to care about the most. Yeah, so I think the feed's just being, they have something that's blocking it and it's letting us see a little clip. I think this will come back in, so why don't we read this article? It'll give us some updates on what happened in the beginning. And if the feed comes back in, we'll just scroll right back up. They're saying a hearing was held, talking about their charges. As the hearing got underway, Clenny appeared in court in an orange jail outfit while her parents sat in the audience. So parents are in the building. Authorities said the parents illegally accessed the laptop that they claim belonged to Courtney Clenny's boyfriend, Christian Obumseli, after the 27-year-old Obumseli was stabbed to death in the couple's Edgewater condo in April 2022. Defense attorneys for the parents said the computer was a shared device between Courtney Clenny and Obumseli, and that the parents were authorized to access it. Authorized by I'm assuming they mean authorized by Clenny, and they're saying that Clenny, it was shared. They're not saying the family of Obumseli authorized them to access it. Courtney Clenny, who went by the name Courtney Taylor on social media, including on OnlyFans, had more than 2 million Instagram followers at the time of Obumseli's death. Miami-Dade prosecutors said the couple had an extremely tempestuous and combative relationship, and that Obumseli was the victim of DV, while Courtney Clenny's attorneys have said that she was the victim and stabbed him in self-defense. Now, so that's the end of this article. We just refreshed it, so they haven't updated anything, probably because they're still in the courtroom. So we'll keep listening to sound. I'll be able to hear it, you guys won't, but if I hear sound, I'll toggle back over. Or we're getting to commercials now. Are we done? Let's see what happens. One more refresh, because I do have another article that gave us some statements that we missed earlier. That's true. That's a important distinction, and I think it might be the journalist that's not catching that distinction. So I wonder if this was just the end of the feed or if they're really still going. Updated 7 seconds ago. Well, we'll have to put a pin on that. The other article, where was it? So, same thing. She's back in the Miami courtroom as prosecutors look to prove that Clenny and her parents didn't have permission. Oh God, ads. Didn't have permission to access a laptop found at the murder scene. Clenny, along with her parents, are facing computer crime charges in the case. Prosecutors say they illegally accessed a laptop belonging to Christian Obumseli, Clenny's boyfriend and the victim in the case. Defense attorneys are looking to poke holes in the prosecutor's theory, saying that it may have been a shared device. Clenny, also charged with second-degree murder, appeared in court in her red jumpsuit. So, red or orange, guys. Miami-Dade Police Detective Andrew Perez. So we saw some of him on the stand when the stream started. He works in the department's cybercrime section, was questioned about his work on the case. Now, I don't know if I caught it in the stream because I tried, as soon as I saw there were no player controls before I set the stream up, I did record like 2 minutes just to catch what I could. And I don't know if it was in that little 2 minutes or if it was right when I started the stream. But when I started watching it, they were questioning this guy about, well, how much work have you done like this as a filter? And he said something to the effect of it being his first thing, his first time. And I don't know if he meant his first time ever or first time on like a major file dump or, looking through felony filter stuff. But it seemed like the guy they had on the stand at the beginning of what we got to see, starting at 4:30, wasn't the most experienced, and he would have thus been relying directly on his point of contact, who was Khalil Quinnan, the assistant state attorney, who we saw him sitting on the side a few times when the camera panned, but he was mentioned. All through that beginning line of questioning, the questions were all about, well, who was that was sending that email to you? Oh, it was Quinnan. Well, who would have told you? Oh, it was Quinnan. Because if you've missed the rumblings up until this hearing, Jude Facadomo, who's representing the Clennys in the laptop case, we saw him do some questioning today. He's been filing motions. I'm pretty sure this Florida Association of Criminal Defense Lawyers press release that was released targeting Khalil Quinnan, pretty sure that was penned, if not entirely, but with the help of Jude Facadomo. They're really trying to say that there was prosecutorial misconduct here. And in part of questioning their filter guy, if the filter guy says, well, this state attorney, ASA, told me to do everything, he's the one that gave me the instructions, and he's the one that didn't instruct me not to do certain things, then the liability for who stepped the line, who should have known better about attorney-client privilege and work product, this guy that brags about his accolades, Khalil Quinnan, we heard Kara getting into that, and he gets up here and tells us how experienced he is, but yet he just looked the other way when it came to communications where Frank Prieto's name and Sabrina Puglisi were parties. It was called Clenny Team or Clenny Defense, and the conversations were relating to the furtherance of their client's defense, Courtney Clenny's defense. Now, the judge seemed to have caught on to this early on. If you kept watching her and trying to coach the other state attorney, I don't know his name, but the one that had the clean cut line in his hair, was standing on the left-hand side of the screen. The judge kept trying to kind of coach him and say, all right, I'm really hung up on this one thing. Can you address this one thing? Can you address this one thing? If they don't know it was a crime and they were just having conversations, then how does this exception apply? You need to make another argument. And the state never got to addressing this idea of, hey, attorney-client privilege exists if the attorney is having a conversation where they expect privacy, They're not standing in a cafe in front of a cashier talking about it. And the discussion they're having is in furtherance of the defense of the actual retained client. So in other words, even though we heard all of this conversation about whether or not Kim and Deborah reasonably could have been perceived as being, clients directly of Frank Prieto and Sabrina Puglisi, there's an aspect of attorney-client privilege where that doesn't matter, because if they were having what they believe to be confidential, private conversations between themselves, they're in a room in person, face-to-face, or they're having conversations, virtually, remotely, but only between themselves, people at the firm and the parents, and the conversations were all meant to be in furtherance, in other words, work product, whether fact or opinion, of Courtney Clenny's defense, then they fall under the attorney-client privilege. And the state tiptoed around that argument. And some of the stuff we get in this article here that we missed, really important. So Perez says Perez says in the discussions investigators reviewed, there were no discussions between the Clennys and their legal team about erasing evidence or altering evidence regarding the laptop. So, no plotting of a future crime, because the crime fraud exception has to involve something that's going to happen in the future. It's, I'm going to go hurt a witness. I'm going to commit perjury. I'm going to go do this thing. It doesn't remove attorney-client privilege of something that already happened. Perez says the laptop was accessed sometime in July, and detectives did not find any indication the laptop belonged to Clenny. Now, that's something that we're all talking about in the chat. I feel like I saw you guys talk about in the chat more than I heard the state hone down on this point. Maybe it just got lost in the wordiness. But this is a great point. You guys are well aware of it. And I don't feel like it was exactly driven home. At least not with the argument that would have, made the basis for some type of crime fraud exception here. Right? Because this hearing isn't about establishing whether or not a crime was actually committed in accessing the laptop. This hearing was not about that. There's a case pending for that. This hearing was about, hey, in all this stuff we came across, because of our filter team, we didn't know any better, did we also happen to come across a crime that's being planned in the future with the attorneys being well aware of it? Well, if you're not accusing the attorneys of being aware of it and participating in it, then that's shaky. That's a shaky argument. And on top of it, if they don't know that the laptop doesn't belong to them, they don't know that anything they're doing on it and continue to do on it is wrong. And then they also sent, which we all agree I think is a self-serving message, Frank Prieto had texted or sent that group chat, hey Kim, now that you've gotten in, that pin worked, don't go in there poking around, because that could break the chain of custody. I'm paraphrasing. But we had read these words when we read the arrest warrants. The videos are back on the page. The live chat should still be there so you could see people like Miranda, and I think Barbara was there too, responding in real time as we're reading these arrest warrants and the affidavits. And to me, it was a very self-serving thing for someone to text knowing that, hey, if anyone ever wants to say that we poked around and did something in this laptop, I have this text message that says, I told them not to do that, right? And Kara referenced it. But what's the problem with that? Just because we can speculate, that does nothing for the state. The state actually would have to have a reasonable basis to say to the judge, look, judge, we think that was a self-serving statement. Here's why. Here's some proof to back it up. And they weren't able to provide any proof that there was anyone acting in furtherance of a crime that would apply to the crime frauds exception. So the questions that they asked Perez, and we unfortunately got to miss it, these statements are pretty important. The detective also says they have no evidence that Obumseli never prohibited Clenny from using the laptop. Now, that sounds confusing to read, but you got to imagine, I imagine this came from Facadomo or Kara and not the state, but they probably asked the question to this guy that was in charge of filtering these messages. They probably asked the question like, and was there anything, did you come across anything that indicated knowledge that was not Courtney's laptop? No. So you have no evidence that anyone knew that Courtney was prohibited from accessing that laptop. No, I don't have any evidence of that. And you can see how that line of questioning is very helpful for what the overall argument Facadomo and Frank Prieto and Puglisi and Cara are trying to make collectively. Prosecutors will have to prove that the laptop was illegally accessed by Clenny and her parents if the case goes to trial. The trial date is yet to be set in the Clenny's murder. So this was written early, but this journalist already knew we are not getting a trial date today. So they had published this article before the hearing was over, but they already knew. The detective added that the investigation was ongoing and forensics were being done on the device, meaning the laptop. So, still a lot going on. I'm going to refresh this one window one more time. And I'm also going to, do I still have it pulled up? Repost the statute on attorney-client privilege here from Florida State. And yeah, so Miranda's saying those statements are important. The prosecution should have honed in on that. Also, the whole scenario around retrieving the pin, they should have stressed that. And that's really, so if you ask me, there was room, because I don't think the judge and I don't think the standard is conclusive proof. But when you're asking someone to make an exception, when you're asking the judge to make an exception to attorney-client privilege, that's huge, right? So you've got to come with more than just, well, we think it could have been in furtherance of a crime. You think? Well, why do you think that? Well, because a judge isn't going to want to make a very loose interpretation that waives attorney-client privilege. I don't know. I don't have sound on this for whatever reason. But it looks like they're recapping it. Do you guys hear this? It doesn't even give me volume controls. Oh, there's the parents. Did he say I love you? Let me know if you guys have volume, because it's not giving me a volume control or anything.
Client attorney privilege. However,
there we go.
Prosecutors say privilege was waived because of who was in this group chat, and they believe a crime was committed when the parents got into that laptop. Now, NBC6 obtained video of when the Clenny parents were arrested in their Texas home. Let's listen.
You have the right to an attorney.
Well, what are the warrants for?
What are the warrants for?
But what is the charge?
The charge is, it's called A1506 out of the state of Florida. It's unauthorized computer access. Okay, so it's basically a hacking charge out of the state of Florida. It's a computer crime.
A computer crime?
Whose computer?
Again, those are details of the case that we'd be happy to discuss if it gets down to that.
This is insanity.
Dang, that's a pretty lucky statement on
Again,
camera for the mom, honestly.
That a crime was committed in this situation, especially the parents' situation. So far, the judge has not ruled. There are several pending motions at hand, and the hearing is still going on.
Hearing is still going on.
As the judge rules, we'll for sure keep you posted. For now, we're live in Miami. Christian Colon, NBC6 News.
Christian, thank you.
Weird. This player is very strange. And we're back to an ad. Now I can't see the volume controls, but I can find them if I click. So, but yeah. Yeah, so, but I think it's interesting that, and maybe it's just coincidence, but I think it's very interesting that NBC6 pulled that clip up specifically. They don't show them being walked or placed into the car. They show a very short snippet, which is neither the beginning nor the end. It's not like they just hit play and let it play for the first 6 seconds, 10 seconds. But they show that clip where the mom, and we can scrutinize it all we want, but at the same time, there could be an appearance of candidness, where it could be candid. It could appear candid that she's like, whose laptop? What are you talking about? It's very interesting they played that specific clip. It could be a coincidence. Right when this whole hearing hinges on, well, they didn't know that it was someone else's laptop and they didn't have access, authority to access it. And they play that one clip. Yeah, the computer that we gave to our lawyers, that computer. But that's what I mean. And they pulled the clip. They pulled the clip. And I wonder, I don't know if any other outlets have updated on the hearing, and it's obviously still ongoing, so maybe everyone's writing their articles and they'll publish them as soon as the final thing. Yeah, like we were in the chats, in like the live chats when she said that, there was a few people that were like, just the eye roll emoji, right? Status hearing. Yeah, still the same outlet. So Local 10 and NBC 6. You know, I'm honestly shocked. This was a pretty big hearing. We had that big filing. I don't think it's like big filing, but it's certainly big for local news. And I would imagine, you know, Court TV, Law and Crime, I'm pretty surprised that they didn't pay attention to the status hearing. They knew extra stuff was going to be on the table. I didn't expect it to be more than 6 hours, close to 6 hours. I thought it'd be like 3 hours. But these major outlets that have this as a high profile, one of the top cases they're looking at, didn't think the status hearing that's been planned a couple months ahead was going to be worth streaming. I think that's weird. Because if they stream some of the other ones. That is a good point. So Miranda says maybe mom didn't know it was dad that was trying out the password. Yeah, she only handles on-call with her daughters. Dad handles all the communications with the business people. And then, yeah, so Courtney seems to do all of it. I was just thinking about how in that disturbance call footage from April 1st and 2nd, it was like midnight. He's like my attorney talking about her dad because she's on the phone with him when the cops are showing up to the lobby of One Paraiso. Yeah, South Florida's most famous resident is on trial in another state. More than one state. Yeah, but usually Court TV, I've seen them do multiple streams before. So, I mean, maybe last minute they had, and I ended up having to get like a lot of work done. I like took the day off and then like, I don't know, like 11, one of my clients was like, hey, what's your schedule like today? And I'm like, oh, okay, let's do this. I have time. I had just set the other video to premiere. And I was like, all right, we could do some stuff. And then 4 or 5 hours later, I was caught up. But I had taken the day off, and I really wouldn't have minded going down there if we don't know that someone's going to be streaming it. Because this stream was locked. I don't see a replay. If a full stream of it doesn't become available, we kind of only have where the stream started to look back at, whatever started at 4:31. So we'll miss all of that, the very beginning, the early testimony from Perez. We won't have if they discussed any other motions or things that needed some type of status update. You know, witness list, we won't have any of that information unless someone includes it. These 2 articles didn't include much else. So that's pretty low on the transparency level compared to other things we've been able to watch the motions in full. I'm going to refresh this one more time. And it is possible I'll check tomorrow too, guys. If NBC 6 maybe ends up uploading the whole video. All these ads. Can tell them this is Florida because it's all the Publix ads.
A family involved in a criminal drama. It's been a very busy day in court for the OnlyFans model charged for killing her boyfriend, but she wasn't alone. Her parents, now co-defendants, joined her in the courtroom. ABC6 reporter Christian Colon joins us with why all 3 family members were in court today. Christian.
It's the same thing we just saw.
Hi there. Yeah, we do know that Courtney Clenny is facing a murder charge for allegedly stabbing her boyfriend to death.
Yes, that's the same thing we just saw. So they must have frozen that clip. So that's what I mean, guys. Whatever wasn't captured in the stream, if they just had that as a live stream, I don't know where we could tap into, you know, being able to catch the beginning of the stream. So we will see if we get to read the judge's order, whatever the judge decides on anything that she's tasked with deciding. we'll probably see some reference to stuff that we missed in the beginning half. And I will check, I'll look around to see. But yeah, the other thing too, if you have Clenny coming to court, because there's been times where she didn't have to appear. You have parents and family there. You have all the attorneys ready. It was like a packed room full of attorneys. You have, I swear they said the family members of Christian Mobenselli, his estate was here. I don't believe it was just the attorney, but maybe it was. But someone there on behalf of Christian Mobenselli was in that courtroom too, at least one person. Well, all these people are showing up for this hearing because they know it's a big deal. I thought there was a lot more in it than I expected, especially coming in at 4:30. We don't get any like actual streams that we can actually watch in full. So that kind of sucks. I'll be more on it next time. I did look around 3, I want to say. And this article that's on the screen was already published, but it was just an ad. It didn't start playing anything with the hearing. So unless maybe they were in a break and they were playing something else at the time and it loaded something like this, like a static video, it didn't look like when I'd seen this around 3 o'clock that there was a stream here even. So maybe there wasn't one. But who knows? Okay, so we know at least the lawyer was there. And yeah, transcripts. So I don't know about accessing those, but the judge did ask them. She asked the court reporter, Marvin or Melvin, can you turn them over? And he's like, yeah, I'll get home, I'll change my clothes, and I'll get right on it. He said something like that because she's going to be re-looking at the arguments that were made in court today to help her inform her decision. That poor court reporter still, if it's still going on right now, is still taking more notes. So, and then, yeah, so, and then Denise, are you referencing the Crumbly case, the second set of parents that have been pulled into court because of their kids? I mean, part of that's just a byproduct of technology, right? It's probably easier to find traces of people communicating with each other about something that happened, and now it's easier to prove that you're a witness or had knowledge, and we need to bring you in, even as a witness, not if we're, maybe you're an uncharged party, but even just as a witness, we might need you. Hey, we don't think you did anything wrong, but we want to use your communications or something you posted on social media, and we need you to come lay foundation. So now we have to subpoena you, have you sit for a deposition, and then possibly have you testify at trial. All because the technology makes the paper trail more accessible, easier to find, and then obviously more stuff is just recorded by nature. Someone in the chat earlier had said, just an interesting philosophical question, right? Because there's obviously technological differences. But how is looking at someone's iCloud account to look at their communications different than a wiretap? And a wiretap would be real time, right? I would be able to sit in and listen while you're having a call live, and accessing someone's iCloud is accessing records, after they've been uploaded to the cloud. And that could be a pretty instantaneous upload. Still just a small difference there. But it is a big question for law to have to consider, and case law to probably have to catch up with. And you're seeing it become relevant in a really, I would say, novel way. Because the defense is like, well, this should have been protected client privilege, but there could be interesting stuff in there that we only uncovered through these search warrants about the laptop. It's my guess, guys, all these notes that we looked at, we're starting to look at, the notes from Courtney Clenny's phone app, notes app in her iPhone. That had to have been extracted, I would imagine, from her actual device, right? So that stuff was part of a warrant for a device, for Courtney Clenny's device. But there's other things that are still subject to a protective order. And back to the technology conversation, we wouldn't have those notes if they were written somewhere on paper, a traditional journal, and Courtney was able to go back to the house and throw them away. For whatever reason, she never thought to do away with the notes in her notes app. Maybe they were syndicated somewhere and they were extracted through there. But it did say it was from a report, which makes me think it was a Cellbrite extraction. And there's some stuff in there that I think is very indicative of Courtney being the provocateur, the aggressor, before and very close in time to April 3rd. But a couple decades ago, that wouldn't even be a possibility, right? We would have had to have found her paper journal before someone did something to do away with it. And that was you, Denise? Yeah. So, but it is like a really interesting, like philosophical type of question, you know? And then I think the judge appropriately said, but what's the scope? Address the scope. And she tried to say the word, and she did it for both sides, but when the defense was doing their questioning of the witnesses, parameters. Ask them about parameters, because she could see that that Kara was trying to say, but all right, where's the limit though? You can just go in and get a free pass to look at anything you want just because you think something might be going on. You're just going to skip the idea of getting a search warrant to get permission from a judge that says, hey, I have probable cause. Will you grant us permission to go and look at this? Will you give us a search warrant? And the judge was trying to coach, you know, I called her Coach Cruz a few times, but in that moment she was coaching Kara, the defense, saying, yes, ask them about parameters, because the judge, that indicates the judge is interested in this idea of, we don't want to give people carte blanche access to somebody's entire iCloud drive. People have a right to privacy. And the state, the government, doesn't have a free pass to just go and look at whatever they want, whenever they want, however they want. Right? Layers and layers of privacy arguments going in here, outside of even just the attorney-client privilege argument. But it's questions that wouldn't have existed before iCloud was a thing. And now it is. And now it's relevant in a pretty major trial. So, note to self, guys, common thing. Don't document yourself. This is not legal advice, this is common sense. Don't document yourself talking about how you cut or stabbed or committed a crime in a text message or in a note, something that has a digital footprint, if you don't want someone to possibly be able to find that. Common sense, not legal advice. And then, yeah, that's why I don't do iPhone. Tara, not Kara. Tara Kawaz. Okay, so she is actually, guys, so I had it wrong. I'm going to put a note in the description. I would have okay, Tara Kawaz is part of Jude Facadomo's firm. So that's pretty interesting. I'm assuming they both got to do questioning then because, you know, there's different parties involved there. Interesting. Now I feel bad. I kept calling her Kara. But that's okay. She's a new face in this case, in the hearings at least. And yeah, keep this stuff on paper so you can burn it. And that's the thing, like in this case, Courtney Clenny, we know she went back to the apartment. We know her dad found everything. If there was a paper journal, if everything that we got to look at the other day in the notes relating to the January face cutting, do you think Courtney or dad would have just kept paper records of that sitting around? Probably not, especially since you look at a journal and you go, oh, that probably won't look good. You'll think about it. So the state, and they mentioned this would be a separate issue. So the state had a warrant to subpoena Apple for the iCloud downloads for the Clennys. It was signed off on, and then it expired, and they signed off on it again, and Apple responded to the subpoena again. And when it expired, I think it's just because too much time had passed. It was like a 30-day window. It wasn't anything weird. Just administratively, they had to apply again. But that was signed by, I forget, what was that? What was that judge's name? Mindy Glazer? Hold on, let me remove this. Go back to here. Yeah, it was Mindy S. Glazer was the judge that signed off on that. And if you heard, that was the affiant for that was also Adrian Perez. So same faces. But if you heard during the hearing, it was closer to the end, they said, oh, we are going to take that up on another day. We have an issue with that warrant for a separate day. So I don't think this is the end of the fruit of the poisonous tree argument that we kept hearing Facadomo name drop. And he said he has a bunch of motions on the way. I'm sure we'll see that come up. It seems like Facadomo is bringing some stuff to the press. I mean, the Florida Association of Criminal Defense Lawyers did a whole press release that I'm sure he helped pen, if didn't write entirely, because it really echoed the same things he was saying in court. And according to news outlets, the Miami Herald, they were able to read one of the motions he filed on the issue, alleging prosecutorial misconduct. They said themselves that this echoes what they wrote in this press release. So, in my opinion, that was the Miami Herald pointing out, hey, Facadomo has a vested interest here, and it looks like this association is writing this thing, and it's on behalf of 1,400 attorneys, but at the same time, the person whose words it's really coming from, the substance of it, is coming from an attorney that's representing clients in one of the two cases, one of the only two cases mentioned explicitly in this press release. So, shout out to the Miami Herald for being pretty astute in their reporting on that press release. And then, yeah, it's even faster now. I forget what I was talking about recently, but it found me right away. It's like the second you open up Facebook, there's an ad about the subject that you were just talking about. And yeah, you're not safe anymore. You get recorded, screenshotted. And sometimes it doesn't help. I mean, talk about the Jonathan Majors case. You have video of you running away. And part of self-defense justification is reasonableness of your response, your conduct after. Well, you're running away. So are you trying to provoke? Are you aggressing? You're running away. And thankfully, there was surveillance footage of it that we got to see in the public. But in the court, even though they did acquit him of the two charges of what would have been intentional, the jury was like, well, you said intentional or reckless. We're going to get him with the reckless ones. But in that case, we only had that because all the buildings have cameras. They got to record a 5-block trip, 5-block mini marathon because of different cameras from different buildings being patchworked together. I don't know. Because they had to go, in this case, for the iCloud data, they had to go to Apple. So, I don't know. Yeah, so Miranda, I'm kind of on the same boat. So I'm not mad at the defense. They're doing their job. But I think he's tying that to the other case with Clenny, right? It was like, oh, you have a big high-profile murder trial where some other prosecutor had to step down because the judge required it. And now I'm going to talk about the Clenny case. Like, that's kind of how that read. And at the same time, on a broader level, guys, I don't think that the state should ever be playing lightly with attorney-client privilege. The stuff that the state is doing, if a judge does decide, Khalil Quinnan was reading attorney work product, it was supposed to be privileged, and now he's aware of the defense's whole strategy, that's unfair to the defendant, regardless of anything else going on, and that could be a mistrial. And then what? If you are on the side, and I'm leaning that way after reading the notes, right? I would have to see something very convincing to tell me that self-defense favored Courtney Clenny in the moment of what happened on April 3rd, right? Because self-defense, you have to have innocence, reasonableness, proportionality. And there's two other elements. I always forget them on the fly. But you don't just get to say self-defense and say you were scared. That's not enough. And all of her notes, talking about other recent events, show that she was the person provoking arguments. That she was the person that would persist and follow and not want Christian to leave. She even says in her notes, I never wanted him to leave. And then we know she said to the police on that day, well, I went across in the kitchen because I was scared, and that's when I picked up the knife. And then he came closer, so I threw it at him. So the idea of them only having so much space anyway, and him coming closer, makes that 10 feet statement sound really weird. But she doesn't say that she tried to go into a room. She didn't go outside. She didn't call for help. She called her mom and seemed to have given her mom a play-by-play. And then continued screaming. And there's also other evidence that the fight started because he was doing something he wasn't supposed to be doing. She mumbles this on the body cam audio. Right? So there's all this stuff that I think is going to be very hard to prove for the defense. I can't wait to watch this trial and see if something does flip where I lean. But at the same time, if you want to see Courtney Clenny convicted, you don't have to agree with me thinking that I think she looks guilty, and from what I know. But let's say you do. Even if you think she's innocent and you're watching this. Put yourself in the shoes of someone that wants to see Courtney Clenny convicted. And then ask yourself if you think it does anybody any good for the state not to follow and respect what they should know could be attorney-client privilege. When you just go looking at things that you're not supposed to be doing, and again, that's why they kept focusing on Khalil Quinnen, ASA Khalil Quinnen. He was the one that was calling the shots and looked at the stuff and told the filter guy, do this, don't do that, or he didn't instruct him properly. They made a point of placing all the burden on Khalil Quinnen, and we didn't see him speak today, at least not in the parts that we watched. That's a problem. It might not mean anything will come out of it. I don't think judges like to wag their fingers at, any attorneys really, not just someone that works for the state versus someone that could just be a criminal defense attorney. But if this gave the prosecutor a look at communications that talked about a defense strategy, that's just grounds for a mistrial if they decide that privilege was improperly broken to a point that can't be reconciled. If it means Clenny cannot have a fair trial, a fair defense, any reasonable judge would, if they decide that that's the case, would grant a mistrial. So you shouldn't take this motion hearing that we watched today lightly. It's possible that what Jude Facadoma was suggesting that Khalil Quinnen did is just a ruse. But it's possible that the government overstepped their bounds. And the defendant always has rights that the state does not. So that's my soapbox. I'll always complain about. And guys, I've previously given credit to the prosecutor. I was like, oh, I think they really handled that well. I think they're doing this reasonably well. And now I'm kind of like, have I been too generous with them? I don't know. And then rewind all the way back to the beginning. They took how many months to decide to prosecute Clenny to begin with? That's another problem, right? That's like the original elephant in the room. Even the laptop. I mean, we were all sitting here in the chat. You got to say it. If they didn't clear the scene, or if they had collected it before they cleared the scene, this wouldn't even be a contentious debate. We could have had a trial date instead of this motion hearing still continuing maybe at this moment. But the police body and the prosecutorial body kind of decided to just wait in limbo. Everything went about its way for, 4 months, 5 months? Yeah, 4 months. And here we are because of a laptop that Dad picked up from the apartment after it was cleared. Yeah. And yeah, the way she demonstrates the flinging that night. But yeah. So I'm going to jump out of here, guys. I am going to refresh and see if we get any other updates and do a quick recap on that. But way more interesting stuff in this hearing than I expected, because all the other ones have been very short, like an hour long besides the bond hearing. And this was fireworks, lawyers on lawyers. And if we get a decision from the judge and we can get our hands on it, we'll at least take a look at the news reports, but maybe read her full decision if that becomes public or if I can grab it. You guys all take care. I'm going to end it here. Thanks so much for joining and for pointing out details throughout the chat all the way through and through. You guys take care. Have a good night.